Is this the digital transformation for SIDS or a different one?
Test.
Yeah, we hear you, but just wondering if it's what's the session name for this one?
Okay. Hello, good morning, everyone here in the room as well as in the Zoom. Thank you for coming to this session on the last day of APrIGF 2023. Please take your seats. And just so you know that this session
Recording
is
in
titled
progress.
"To Protect or Harm the Tensions Between Privacy and Civic Freedoms in Personal Data Protection and What It Means for Civil Society Organizations." So if you think, even if you think that you attend the wrong session, please just stay. Please just stay. My name is Deborah. I am project manager for data policy and governance at TIFA Foundation in Indonesia. I will be moderating today's session, and I am assisted by my colleague here, Berna, who will be keeping up with the interactions in the Zoom platform. So before we go to our brilliant four panelists, two are present here and two are online, Anindita and Aris, I would like to just set some context and maybe set the expectations of what we will explore in this session. So countries in Asia Pacific, we have been adopting data protection regulation in our jurisdictions. Some are prompted, some are actually earlier than the others, some are prompted by what you can call the Brussels effect, which can actually explain how the enactment of the General Data Protection Regulation in the European Union actually has led to the emergence of similar regulations across the globe. And many of us are actually cheering this development or progress of the enactment of data protection law in our jurisdictions. However, in this session, rather than looking at the effectiveness of these laws in addressing the risk of privacy violations, as well as in mitigating the adverse impacts of these violations on the data subjects, we are going to focus on how, despite the virtuous intention behind the development and enactment of such law, there are some provisions that are actually threatening civic freedoms, ranging from freedom of expression, freedom of the press, and so on and so forth. And therefore, such law actually contributes to the shrinking political and operational space within which civil society is actually operating. As we will learn from today's panelists, both online and here, data protection law puts in place legal protection of for personal data processing and provides more control of data processing in the hands of data subjects. But the devil is actually in the details of the law. The risks of to civic freedoms posed by such law range from unbalanced or disproportionate cost of compliance that are imposed on data controllers in the public, private, and civil society sectors. And another source of risk is actually the potential abuse of the PDP law to silence criticisms and dissents on the grounds of non-compliance or even the failure to prove compliance with the law. So the situation is concerning because civil society organizations in Asia are increasingly becoming data-heavy operations. Therefore, negligence or the lack of capacity to prove compliance actually creates a lot of risk on them, not only financially, but also reputational risk, which can result in the loss of trust from donors and supporters, for example. And we might think of GDPR as the golden standard, but if we can also turn our heads to already happening cases in Hungary and Greece, for example, in which the GDPR has been used, instrumentalized as a SLAP strategy, strategic litigation against public participation, particularly against the media organizations. We can learn from that even if this golden standard itself still pose a lot of risk to the civic freedoms. And learning from these cases, we're going to explore what's at stake in Asia, particularly focusing on Indonesia, the Philippines, and India. And we are going to explore how these tensions of privacy, protection, and civic freedoms in the data protection laws in these three countries can affect civil society and even the civic space itself. And of course, we also want to look forward. We want to find potential solutions to address these problems and challenges and explore how civil society can stay resilient amid this law. And to discuss this, we already have 4 panelists. Present here with us is Maristela Miranda. She is a senior associate from Lights Institute in the Philippines. She regularly assists organizations with their privacy program development on information management, digital security, and community media. She regularly assists organizations with their privacy program development implementation, and she's also a certified information privacy manager. And Ferdi is the program and innovation unit manager from Combined Resource Institution in Indonesia. He supervises the implementation of programs on information management, digital security, and community media. And joining us online, Anandita is currently studying law at the New York University. Previously, she was Associate Litigation Counsel at the Internet Freedom Foundation in India, and she has participated in litigation efforts to advocate for the digital rights of Indians. And last but not least, obviously, Aris is Community Engagement Facilitator from Combined Resource Institution in Indonesia with a lot of experience in digital security and community media. I'd like to give the opportunity first to Ferdi here to explore or to give a preview to us about the privacy threat landscape in Indonesia and how the capacity of civil society organizations for compliance is in the country. Ferdi, you have 10 minutes.
Okay, okay. Hello. Okay. Okay, good morning, everyone. My name is Ferdi. I'm from Combined Resource Institution, Indonesia. Here, we are going to share our findings about the readiness of CSOs in Indonesia to comply with personal data protection law. Okay, and
Jasmine, can you please put the slides on?
Yeah, the next slide, please.
Next slide. Next slide.
Next slide, please. Oh, I'm sorry. Control. Yeah. Bisa. Nggak bisa. Mana nih? Yeah. Okay. Sorry for technical. Yeah, these are the headlines of data breaches cases. One is a headline from the dark web that happened in the first half of the 2023. It's all in Indonesian language, of course, but you can see the numbers like 300 million, like 34 million, 15 million. That's all about the data breaches in Indonesia. And okay, that's the headlines from the BBC News, Tempo, and even from the ministry itself. So 100 million the population and civil registration agency data from the Ministry of Home Affairs were allegedly leaked. 15 million from Bank Syariah Indonesia, customer data allegedly leaked, and there were 35 cases of data leakage in Indonesia from January to June in 2023, said by the Ministry of Communication and Information that responsible for this issue actually. And the situation, next. On September 10th, the Indonesian government passed the law number 27 of 2022 regulating data protection. This is, of course, a long-awaited regulation because the draft has been made since 2015. Since then, the government and the legislators never reached an agreement about it until Bjorka, if you ever heard about her, the name, the hacker leaked the BPJS Ketenagakerjaan or worker insurance data in 2022. The leak case is just like a catalyst because the government and the legislators thinks they really needs the data protection law right now. And yeah, of course, the CSOs really appreciate the passage of the legislation, but yeah, we have a hope for fair law enforcement for personal data violation because before 2023, we have a lot of data breaches, but there are no law enforcement. And however, this regulation still leaves loopholes. Okay, next. This is the challenge about the regulations. So the risk to the right to information and freedom of the press. Data protection exceptions don't appear to take press freedom and information rights into considerations. Like for journalists, the media, and the CSOs that engage in advocacy work to expose the abuse of power. This could be threat for criminalization. Yeah, for example, like criminal records and financial data are included in specific data. It would be difficult for the press or CSOs to use it as an evidence of abuse of power or crime by the public officials. Yeah, the government can do anything in this situation because they could oppress the press of CSOs, even worse, criminalize both in the name of national security. Relate to the first one point. So the exemption of the fulfillment data subject, including like national defense and security. And then the enforcement, the next challenge is enforcement on public personal data controllers is too soft, even though the cases of personal data leakage often occur in government organization. And yeah, the last, the Data Protection Authority will be chosen by the president and the regulation and has the potential to interfere the independence of the institution. Of course, the CSOs and academia hope that the authority is an independent institution, so they could be more free of the conflict of the interest. And yeah, next, the question is, yeah, are these CSOs ready yet? So from the end of 2022 and the early 2023, TIFA and Combine conduct a baseline assessment of personal data protection practices by CSOs in Indonesia in order to arrange a data protection training module for CSOs. And in this assessment, we use survey methods, and there were like 109 respondents from 96 organizations in the sample. The basic assumption is that CSOs are not yet prepared to comply with data protection law because we are not familiar with with this issue. Actually, most of CSOs in Indonesia not really familiar with this. And yeah, about this assessment, of course, it's an initiative. This baseline assessment has limitations. The result cannot be generalized, but at least they can illustrate the situation of the data protection practices amongst Indonesian CSOs. Okay, this is the findings. Yeah, most of them said that this issue is very important. This is a good investment for the CSOs practices in Indonesia. And next, yeah, this is about the second is about technical safeguards that they have in the organization, like 68% they said didn't have adequate safeguard. 42% answered yes, they have. But this point is very subjective. Of course, the result has to follow up with some technical measurement to answer the can be more valid. Okay, next. Yeah, this is the point about the data policy organization. 58 said they didn't have the specific internal policy regarding personal data protection, and 42 said yes. Yeah, the results suggest that the majority of CSOs that were met respondents are still not adequate prepared to protect data, the personal data they manage, which make them more vulnerable to data security incidents. And the last is about the data protection officer. Most of them said no, they didn't have the data protection officer. And yeah, CSOs do not seem to ready to fulfill the mandate of the law. The absence of this function within the organization makes the organization more vulnerable in terms of managing data protection, puts the organization at risk of neglecting the PDP aspects of its work. Okay, this is the last, the analysis. So yeah, personal data protection is seen as a sectoral issue in Indonesia. The lack of awareness of members of the organization for the protection personal data has a serious impact on data protection policies in the organization. Increasing awareness is not enough. It must follow by creating proper internal data protection policy, of course. And CSOs are not ready yet to comply with the personal data protection law. Limited resource, both human and financial, are the possible main barrier. And this law can be a backlash, not only for CSOs who are not ready yet to comply, but also for CSOs who always criticize the government. Okay, that's from me. Thank you.
Thank you, Ferdi. Later, we will have Anandita. Are you ready to share about how the newly effected, it was just 2 weeks ago, 2 or 3 weeks ago, Personal Data Protection Act in India, how that act may threaten civic freedoms, including but not limited to the freedom of the press, free expression, as well as the right to information. Do we have Anandita's slides ready? Can you please put the slides on India? Sure.
Well, thank you, Deborah. I'll start while the slides are being put up, right? Am I audible to everybody?
You are.
Okay, perfect. Good morning, everyone. Well, okay. This is a heavy early morning discussion, but I will try to keep it as engaging as possible. So the Data Protection Act in India, it was passed, like Deborah mentioned, earlier this month. So it hasn't really been a long time. However, it's been going on since a really long time in India. The parliamentary discussions, reports on the bills, so significant changes to the bills over the years that has been going on for a long time, which has finally culminated in this act. There are lots of civil society concerns already about the consultation process, how a lot of views of the experts on the previous existing bills were not taken into account. Some were, and this sort of continues to be one of the concerns that civil society is fighting right now. But without going into detail about that, I would just straight away jump in and tell you a little bit about the Act before proceeding into telling you how civil society may get impacted, because right now we really do not have enough data to talk about how civil society is able to comply or not comply with the Act. But let's see how it can pan out, right? So starting with what the Act protects, the Act is called the Digital Data Protection Act, right? And it only pertains to personal data. So non-personal data is not a part of the Act at all. It is only protecting data that is being used or that can be used or that is in relation to identification of an individual, right? So that's personal data as defined under the Act. Whom does the Act apply to? So it applies to any data that is being processed in India after collection. And it also applies to data that is being processed outside India, provided it is in relation to any activity that is offering goods or services to data principals within India. So say it's my data and I am, say, purchasing something on an online website, which is situated out of India. It is processing my data with respect to that purchase in order to make that purchase happen. Therefore, the Act will have jurisdiction on that data. I'm sorry, did Bernadette say something?
No,
Okay.
please continue.
Okay, I'll carry on. Yeah. What does it not apply to? It does not apply to personal data of any individual who is processing their own data by themselves, right? So it being publicly available in some capacity impacts the application of the Act. The Act clearly says that personal data that is being made available by the data principal on their own is not within the purview of this Act. So this, makes this question arise in a lot of people's heads. Say you're using Instagram and you're sharing your pictures, but you have a private account, not a public account, but you are putting your own information out there, right? Does the Act protect that? Not protect that? We don't know that yet, right? Okay, so now one of the provisions that the Act has added that helps data principals or provides them a way to enforce their rights is the requirement for consent. So the Act clearly says that a free, specific, informed, unconditional, and unambiguous affirmative action will constitute consent from a data principal to a data fiduciary for processing their data, and that is essential. The data fiduciary has to give a notice to the person in a language that they understand and which is within the Indian Constitutional Schedule 8. And it is only after that consent is given can data be processed. The right to withdrawal has also been granted to the data principal in case they want to withdraw their consent, right? So this is a good provision, in my opinion, to start with, right? Now, this is where the first problem comes in. If you have the slides, it says that data can be processed for certain legitimate uses without the consent of a data principal. So basically, this means that your consent will be deemed to have already been given in certain situations. This starts off very simply in the Act by saying, that for purposes such as you going to a restaurant, giving your number for reservation, it means that you've provided your data voluntarily, and therefore there is consent to process your phone number for the purpose of making that reservation. It starts off like that, but as you keep going down and as you go to slide 6, or, even slide 5.2, it becomes wider and it grants a lot of power to the state to process individual data without their consent. So it states that for the purpose of providing any subsidy, benefits, service, license, or permit, if you have given your data, the state can use it even in future, right, without your consent. Then again, a provision that has been argued to be very broad is that data can be processed with the performance by the state or any of its instrumentalities of any function under law or in the interest of sovereignty, integrity of India, or security of state. Now, these terms in itself are very, very broad and they are not defined and they are very subjective, right? So these provisions can be used in a manner that may be exploitative towards the data of a data principal, right? Similarly, there are more provisions like the data being processed without consent during, say, an epidemic, like if there's a pandemic again, hope so not, but that's when the data can be processed again. So that is something that is really problematic because it is very broadly worded and consent can be assumed without having actually given a notice and taken an individual's consent. Coming to the last slide, there are certain more exemptions that I would just briefly touch upon. I told you already about the consultation process and how there have been problems surrounding that. We've discussed notice, we've discussed the deemed consent, so-called deemed consent provision that existed earlier, which has been changed to certain legitimate uses now, for which consent may not be required. The provision for data transfer right now is not clear. The government will notify a list of countries to whom data cannot be transferred, right? So right now we do not know how that's going to happen, to which countries data can be transferred, etc. Broad exemptions, like I mentioned, or there is very wide exemptions provided for state and its instrumentalities to process individual data, right? Coming to Data Protection Board. So the Act establishes a Data Protection Board. It says that the Data Protection Board will be appointed by the central government. However, it does not provide how the central government will decide who is going to occupy that position, what would be its composition, and therefore it leaves a huge question mark on the independence of the board, which is essential because if a board is hearing, say, complaints against the government and the central government is appointing the board, it's essential that it has members that are unbiased and can look at a complaint from a third eye perspective, right? And in line with principles of natural justice. So that is a huge question mark right now. Impact on right to information. So the Act actually amends the Right to Information Act in India, which has been sort of really important for civil society in the past years, where civil society files RTI, right to information applications, with the government, with private bodies, etc., to get information on issues before they address them. The Right to Information Act in India has an exemption provision, which says that in certain circumstances, the person from whom or the body from whom you're asking for information can deny information on certain grounds. Now, this Act has amended the exemption provision in the RTI Act to include, and I would quote, information which relates to personal information. So basically, any information that relates to anyone's personal information can be denied in an RTI application, which again is really broad because a lot of information is personal information at the end of the day these days, right? So it really impacts the Right to Information Act in India, which is something that civil society is trying to fight now. There is excessive delegation because a lot of procedures as to how the Data Protection Board will be constituted, etc., have not been put in the Act, and it has been deferred later to the forming of regulations, which will determine these issues, right? Then there are penalties for data principals, of course. What is surprising is that there is no penalty for a data principal in case of a breach if the data principal shows that they have taken reasonable security measures to prevent a data breach. Ferdy showed you data on the amount of data breaches that have happened in Indonesia. We have similar figures in India. And what is surprising is that a data fiduciary can actually get away with paying any penalty if they show that they took some security measures which are considered reasonable by the board to protect them, right? And then, the data fiduciary will not have any, recourse if it's found that security measures would have been taken and there's damage caused already, the data has been breached, right? That is also one of the most problematic principles that civil society is fighting in the Act. And then...
Sorry, can you wrap up in 1 minute?
Yes, okay.
Thank you.
And the last provision is about additional obligations to significant data fiduciaries. So this is where I think there's a huge impact to civil society. The Act clearly says that it is going to list down certain fiduciaries as significant data fiduciaries on the basis of certain factors. These factors include the volume or the sensitivity of personal data that the organization is processing, risks of rights to data principle, risk to electoral democracy, security of state or public order, right? Now, given how civil society functions, its actions at times are not in consonance with what the government is doing, right? So this provision can be used to notify a civil society organization as a significant data fiduciary. Now, a significant data fiduciary has additional obligations like appointing a data protection officer, doing regular audits, appointing an independent auditor, doing a data protection impact assessment, etc., which highly increases costs for civil society in India. One of the struggles of civil society in India is to get enough funding to get the wheels running in an independent manner, right? And this may really impact compliance costs as well as the operations of civil society, and it may, affect their output negatively. So this provision is something that civil society has to watch for. We don't have enough data yet to see how it's going and who's complying as much because the act was just passed. But we hope to know soon how it's doing in India, and civil society is already fighting on the points that I flagged for you.
Thank you, Anandita. So even just between these two countries, India and Indonesia, we can already see shared challenges. But these two countries, we have just we just issued our laws. So we want to hear from a country which has already had some experience of implementing the law, and to hear more about the, of course, about the problematic provisions, but also on the adverse repercussions of the law. And Maristella here as a practitioner, as a data privacy practitioner, she can also share about what civil society can actually do to increase their resilience amid these challenges. Maristella, over to you. Please put the slides on, please.
So good morning, everyone. So I will keep this as short and as simple as possible. So I will not be really talking about the law itself, but how we apply it in the Philippines and how it affects the people's rights. So this is data privacy in the Philippines, the tensions between privacy and civic freedoms. Oh, okay, it's changed. Why is it like that? So anyway, so data protection laws, we know what its main goal is: to ensure that anything that you do with personal data will be lawful, that it will protect the human rights. But we also recognize that it is not meant to restrict any flow of information. We just want to make sure that everything is made legally and in respect of the rights of the people. So, however, as seen there, though it changed the slide. So anyway, these laws are sometimes prone to abuse, whether in full or partially. So how are they infringing on the rights of the people? So we will see in the next slides. So what we have here are some examples on how the Data Privacy Act is actually misinterpreted, whether it is parts of it are misinterpreted, or as a whole it is misinterpreted. And when it is invoked, it actually prevents people from exercising some of the rights. For example, the Securities and Exchange Commission took down their system, which prevented the journalists from checking dummy accounts in the Philippines. And the other is when government officials are actually denying access to their statements of assets and liabilities and net worth. So it prevented the public from seeing which politicians or public officials are actually involved in fraudulent and corrupt practices. And I want you to look at this section. So our Data Privacy Act, it has some exceptions. And one of those exceptions is when personal data is going to be processed when it is necessary for public authorities to carry out their functions. So it is under the exception. But it is only to the minimum extent necessary, which means that you still have to uphold the rights of data subjects, ensure the security of personal data, and uphold the privacy principles. But if we read this together with the next slide, we can see here that even if they are outside of the scope of the Data Privacy Act, it is still included in the criteria for processing personal data. So if we see it in one way, like it is the government wants to ensure that it will be able to process personal data for its purposes. So one thing, they say it's not covered, and then in the other slide, we can see that it is part of the criteria for processing. And why is this prone to abuse? Why is it dangerous? Because in the Philippines, if you know of red tagging, so red tagging means you are labeling individuals to be communists or against the government. So anything you say that is against the government can be interpreted as something that is for communists or terrorists. And we've had examples like this one. So during the pandemic, we had what we called community pantries. So community pantries are self-organized, like mini stores where people can line up and get what they need. But then police started asking questions who these people are and asked them to fill out forms asking which organizations they belong to, what are they doing there, etc. So the people were actually scared. They stopped doing it for a while. And there had been instances that the people who volunteered were actually red tagged. And it's not the first time that this happened in the country. Next slide, please. It also happened with a group of teachers. So ACT is a group of their Alliance of Concerned Teachers. So they are a progressive, militant, and nationalist organization of teachers and other workers in the education sector. So the Department of Education requested for this certain list of individuals or teachers who availed of the automatic payroll deduction system. So if we look at it, it seems harmless, but the teachers got scared because a previous instance where a list was got from the teachers or the schools, it was used to label again the teachers as communists, as terrorists, and the group said that consent was not obtained. But if we look at the provisions earlier, we can say that consent may not really be necessary in this case because the Department of Education can easily say that they need it for their function as a public authority and for the legal obligation of the school to provide these names. And it also happened with a group of lawyers. So lawyers who represent those who have cases against the government are labeled also as supporters of communists and terrorists. And also this DILG, or the Department of Interior and Local Government, they also requested for a list of their employees who are members of this certain group called Courage. And of course, the fear is there because red tagging is happening within the Philippines. But let us now look at how this affects CSOs. What does this mean for CSOs? So this is more of the organizational effect to the organizations. So there's the lack of funds. So what do we mean by lack of funds? Because you need to comply with the data protection law, it means that you need to have some funds to do it, not just to protect personal data, but because there are certain requirements like registering your data processing systems, appointing your data protection officer, that requires funds because that is not part of the usual budget that they have. And this also requires funds because when you file a complaint with the National Privacy Commission and you request for an investigation, there's a fee for that. And when you request for an advisory opinion or legal research, it requires funds. And if you look at the second photo on my left, So it says guidelines on administrative fees, and below that are actually the penalties under the Data Privacy Act. And you can see that there are fees if you do not follow the privacy principles, if you violate the data subject's rights. So if the organization is not ready, like what they have mentioned, if the organization is not ready, they are most likely will violate the Data Privacy Act, and it will entail costs. And then the lack of manpower. So we know that they have to designate a data protection officer, and not all organizations have data protection officers. So what they do is they just appoint someone already in the organization to do the responsibilities of that officer, and they cannot hire somebody else because of the lack of funds. So it's like you have this one problem with funds, and then it affects all the other requirements and capacity of the organization to comply. Next is the lack of data protection training or data privacy training. So even if you have people, if you have designated a data protection officer, it doesn't ensure that you will be able to comply, because not everyone knows how to interpret the law. Not everyone knows what to do. So it was common for us to encounter organizations who do not know where to start their compliance. And it is common also in the Philippines to have organizations who have policies who are not documented. So they follow their own practices, they follow verbal policies, but it's not written down. And we know that part of a robust privacy program is to have things documented, to make sure that it will be uniform across the organization, and it will not just change from day to day. It will not change with just because you think that this should happen. So it is common to encounter this. And when you are unfamiliar with the other data protection requirements, if you're an organization that processes personal data of foreigners, and it is still covered by the Data Privacy Act, let's say. So if you don't know which requirements apply to you, then you are most probably be already violating some of those data protection laws. So what does this have to do with their image? So if you do not comply as an organization, you may damage your reputation, because there are a lot of data breaches happening and people are becoming more aware of their rights. So if they do complain through social media or the National Privacy Commission, then your reputation would be damaged. You will lose the trust of your beneficiaries, members, partners, or even funders. And there are legal repercussions. In the Philippines, if you've noticed earlier, it's not just paying fines. The DPA, or the Data Privacy Act, says that you will be imprisoned and you will have to pay a fine. So that, I think, is one of the unique characteristics of our law. Do I need to proceed with a? Sure. Okay. So how can the CSO stay resilient in the face of potentially repressive data protection law compliance requirements? So of course, you need to upskill. You need to upskill the people in your organization, because the laws are always changing. There are always circulars being issued by the commission, and you build the capacity so that you will ensure compliance and a change in the culture of your organization. You should also know where or when to stand your ground, because it's not always the case that when the government asks for information, it's always legal. So you have to know the grounds wherein you can deny access to information to protect also the people in your organization. You should also include data protection in your budget considerations, because we've seen earlier that it requires budget to comply. So how can CSOs participate meaningfully in policy processes, implementation, and data privacy advocacy? Of course, you have to actively participate in all policy-making processes. So like this one, you need to get involved in public consultations and forum. If there's the submission of position papers, you do it as an organization. You need to extend research support to policymakers, because not all of those people who are deciding for our country know about the technicalities of such as the data protection. So you need to extend support to them. And for those with the capacity to do so, some CSOs provide free training to other CSOs. So that would be very helpful. And you should produce information, communication materials, education materials, and you should take advantage of social media. So it will spread your IEC materials pretty effectively. And what are the opportunities for a transnational civil society collaboration in the advocacy at the intersection of data privacy and civic freedoms? So collaborative research efforts, so between TIFA Foundation and maybe some other organizations in the Philippines and India, that would be really helpful, especially when our data protection laws have been around for quite some time, and maybe we can share some insights with their organizations. And we should express solidarity when dealing with common and critical issues. So as a nation and as a region, we should stand up and make our voices heard as a region and a group of organizations who believe that data protection should be upheld. And we should share and pool our knowledge and best practices and produce materials about it. And of course, the funding support. Funding support will really go a long way. And I think that's it for me. Thank you.
Thank you, Maristela. Thank you, Ferdi, and thank you, Anandita. So Aris here is on standby to help us explore more and about the challenges in Indonesia, in relevant to your questions about the situation in Indonesia, because we have a lot of data breaches and we have a lot of problems even with the enactment of data protection law. So before we discuss further with the panelists, I would like to open the Q&A floor to all of you who are present here and also all in the Zoom meeting room. In case you have any questions, or I heard yesterday as well that colleague from Korea, from South Korea, also shares the same problem, the same challenges, in which the personal data protection law in their country has been instrumentalized to shut freedom of the press. So in case you also have any knowledge or experience about the same challenges, you might want to share and also discuss probably what has been the good practices that you have employed, which we can also learn from that. Is there any questions? Is there any raise of hands? Sorry. Okay, there's a question from Fred Goodert. I hope I do not pronounce your name wrongly. So related to the Philippines, can you share about the case of Jose Rizal Pajares, the reporter with Radio Natin, who was arrested by the Iriga City Police after trying to access police blotters under violation of the data privacy law, and how the law can be used against journalists? Maristela, over to you.
Yeah, so I have heard about that use, but I'm sorry to say that I'm not quite familiar with the case. Yeah, but yeah, the misinterpretation of the law and using it against journalists is not far-fetched. So it can be really used by the government to stifle any voice that is critical of the government. And it's common in the Philippines.
Thank you, Maristela. Is there any other question from the floor? Oh, not yet. But probably if we can also explore and hear from Aris. Are you on standby? If you can also share, do you have any experience of probably helping communities or data subjects to advocate for their rights to obtain some kind of compensation, maybe from the government over the breaches or violations of personal data protection rights? Aris?
Okay, thank you, Deborah. Good morning, everybody. I just want to take you back to 2 years ago. In 2020, there was a massive protest in Indonesia regarding the passing of a job creation bill. So SafeNet, Southeast Asia Freedom Network, Freedom of Expression Network, recorded that there was 20 doxing cases which were most of the victims were journalists and activists. So this data protection bill should be the answer for that kind of case. But right now we still, facing that kind of doxing cases in social media. There's a lot of. I just opened my social media, and still we still have that kind of personal data exposing by someone with no authorization on that. So about a week ago, we have a workshop in South Sumatra in Medan with Indonesian journalists about. We were talking about holistic security, and there was one very interesting question about this privacy issues in Indonesia. The question was, why should we protect our personal data? Because it's already there. I mean, there's a lot of breaches cases in Indonesia. So actually, we are open source country actually. So why do we have to protect our personal data? This is a question from a journalist. This is a very interesting perspective. I mean, it sounds desperate, but that's the reality. I mean, whatever the law applied, the governments always win. It seems that the general, expression in Indonesia. But the point is, this law could be something if, but with condition. I mean, for GSO with a huge resource, it can be easily for them to, comply with the law. They can easily send their staff to digital security training or data management training or something like that. But for GSO that have a very low, budget, low scale, it could be a problem. And the recent development in Indonesia is many sensitive cases is happening in the remote area, which is, they are far from access to information, far from access to data security training, something like that. So this is a huge challenge for us in Indonesia. And I believe this challenge will getting bigger over the years, because right now they are facing face to face with the giant mining company or plantation company, which very far from media sport. So I think yes, I can say that this data protection law could be the answer, but in the other hand, this could be a backfire for GSOs in Indonesia. Back to you, Deborah.
Thank you, Aris. So yes, you have heard, I mean, it's good that we have data protection law in place, but it is important to continue the advocacy so that the law that we want is there. So the law itself can be better improved to fit the needs of the people and also be more proportionate in imposing obligations and also in imposing and also putting in place sanctions for all of the stakeholders that is related to the law. And as we have heard from Aris earlier, that unequal level of awareness, not only between different data controllers in different sector, but even within the civil society sector itself is a problem. And in countries where urban and rural inequality is actually as high as Indonesia and maybe in the Philippines and also in India, civil society in the urban areas and also which have a lot more resources can have better capacity for compliance, but that is not the same case with civil society organizations in the rural areas. I would like to check again with the floor if there is any other questions or maybe remarks from you about the talks today. Raise of hand.
Deborah, can I add? So yeah,
Of
so I
course.
searched for the case. So I read it, but I wasn't able to fully digest it before. So yeah, so the case was this journalist wanted to access the police blotter list so that he can create his news article. But then the police said that what he did was unauthorized processing of personal data, and it violated the confidentiality of personal data. So it is good that police are actually, they do have this procedure, but the question is, where is this written down? Where is this policy? Is this the same for everyone, or is this just this case wherein they don't want that journalist to access that information? So the journalist was detained, he was arrested, and he posted bail after 3 days, and it was 10,000 pesos. So that's the case. So it is balancing the right of journalists or the freedom of the press and the right to privacy. So in this case, it is still questionable.
The addition. And I mean, like TIFA Foundation, even though we are the organizer of this session, we are also working on these personal data protection issue. We understand that, for example, not only that we have to increase the capacity of civil society organizations itself in terms of compliance, but we also need to strengthen these, if you can call it, network of support, because not all of these capacity can exist internally within the civil society organizations itself. You will still need, for example, legal experts, public advocates, public advocates who have the skills, who have the knowledge about how to advocate for the privacy violations of the vulnerable communities, for example. And you will also need a public advocate who can advocate for the press freedom in the face of the repressive, quote unquote, personal data protection law. And you will also need digital security and safety experts outside of your organization who you can always contact or ask for help from in case of data breaches and so on and so forth, because the burden of compliance, burden of proof of compliance lies in the data controllers, and in this case, civil society organizations themselves. So not only private sector organizations, not only public sector organizations, but also media organizations and civil society organizations. And I believe we can also learn from what Combined Resource Institution has been doing around increasing the capacity of vulnerable communities and groups on their personal data protection. They are actually focusing on groups which have not received any training on digital security and data privacy yet. So even if you are an organization that provides this kind of capacity building, you need to have that kind of needs assessment first, right? I mean, you want to target the kind of groups that have not received any kind of training in this space, and you want to invest in that. And for example, Maristella's organization is also helping with even more advanced, I would say, step, which is developing the privacy policy of civil society organization and other organizations so that they can comply more with the personal data protection law. And Anindita here helps with the litigation efforts around digital rights, but that will also include, I believe, data protection with the enactment of personal data protection law in India. I think we only have 3 more minutes. So if there is no other questions from the floor or from the Zoom, I would like to give the last opportunity to also for Anindita, if you can share just a bit with the enactment of the data protection law and with the concern around Aadhaar. I hope I pronounce it correctly, the digitized welfare system, Aadhaar. If you can share briefly what civil society which work with these vulnerable communities can do to ensure that with the enactment of the law, their data, personal data, particularly that is processed in Aadhaar system, can still be protected.
Okay, so earlier the Supreme Court of India, when it recognized the right to privacy a few years back, had said that not having an Aadhaar card or not having an Aadhaar number cannot remove you from the number of people who are getting services. Basically, if you don't have an Aadhaar card, they cannot say no for you to get services. There was no data protecting your personal information associated to Aadhaar then until now. Aadhaar records your name, your phone number, your email, your address, your fingerprints, your retina scans, right? It's a lot of sensitive personal data, not just personal data. As of now, as per the Act, there is protection granted if you give your consent to your data being processed for the purposes of getting the service. However, the Act very clearly says that if you withdraw that consent, the data principal will have to bear the consequences of that withdrawal, right? So if you withdraw your consent, say for a particular thing that is being processed under Aadhaar, you may not get the services that you want, which is problematic. You do not need my retina scans probably to give me access to the public distribution system to get wheat, right? So the Act is very blurry on that. And it may affect services if somebody wants to withdraw their consent, but it also provides provision for protection of that data. It does.
Thank you, Anandita. Not to leave you, not to finish this session with a pessimistic note, but please, even if you think you are not that aware about the data privacy landscape in your region, please, after this session, you can probably spend some more time to look at how the threat landscape for data privacy in your country is, and get in contact, get in touch with us. We look forward really to actually forming alliance of data privacy activists, advocates, whatever you call it, so that we can make even bigger impact, not only in our own jurisdictions, but also globally and also regionally, Asia Pacific at least, in terms of having more rights respecting and also proportionate data protection law, and more needs-based capacity building for civil society organizations around Asia Pacific. I think I will finish this session and on that note. Thank you for participating in the session, even though you do not raise your hand, but I'm sure that we will still be in contact even after this session, even during the coffee break. Thank you, everyone, and thank you, everyone in the Zoom session.
Thanks, Deborah.
Thank you.
I'll just remove my back. It's like I can't talk.
Yeah.
Thanks so much. Really shiny.
still I expect a lot of organizations and actually our organization for the past year. And first, the press, because I met that sound everything. The journalists.
Don't stay in.
Yeah. I my colleague.
Hi, Buyong. Buyong, do you want to try a bit with your audio? Hello, can you hear me well? Hello, this is Buyong speaking. Hold on. Buyong, are you able to speak for a few sentences? Hello, can you hear me? Yes. Loud and clear. Is it good? Hi, I'm Rita. Do you want to try to speak a few words? So we just want to make sure your audio is great.
Yeah, hi, hope I'm audible and visible.
Yes, visible
Thank
and
you.
audible. Thanks, Amrita.
Hi, Sarah. So I did ask her directly. So, so it's registered as the Cyber Cafe Association of India, but that may be a misnomer, given what they're doing now. So she would prefer that you just refer to it as COIS. And I suggested that we qualify it as an internet advocacy organization, but I'm waiting for her to respond.
Okay, so it's an really just grab line. It's an advocacy organization.
Internet advocacy organization in India.
Right, that'll do.
Yeah. Okay. You need anything else from me?
From India. And not, yes, your last name, the Guzman.
Yeah.
Bo Young, I think that is Bo Young. Bo Young. Bo Young. And Anya Gango.
Yeah.
Anya Gango. Oh, I can see it. I'll see it at the end. Bo Young. Bo Young. Bo Young.
3 minutes, 77, so yeah. So full.
Yes. Yeah.
Can you put your bag there just so we don't
Ladies and gentlemen, good morning. Good morning. Please take a seat. Welcome. Those out in the hallway, please come join us. We'll be starting in just a moment. I'll see everyone. Good morning. And just checking you can hear me up the back there. Yep, great. Good morning. My name is Sandra Davey and I am the lucky MC for the next 55 minutes or so. Before I start, I would like to acknowledge the Yugara Turrbal people of the Meanjin Nation and pay my respects to elders past and present, and also extend my respect to any elders, Aboriginal or Torres Strait Islanders that may be joining us either online or in the rooms today. Thank you everybody for joining us in what will be a really interesting session. I'm delighted to be emceeing this and I'll welcome the panelists in just a moment. It's pretty tight. We've got 6 fantastic speakers and 55 minutes. So it's going to be an interesting job for me to keep everybody to time, but also to allow time for those of you that are joining us online. I will be monitoring chat if you have any questions. And of course, in the audience today, we hope we've got some time. We're really aiming to have time towards the end to engage with the audience. Each speaker will have a really tight 4 minutes, but all of them are experts in their field and bring a range of experience in internet governance. So I am sure they are able to stick to their time. First, I would like just perhaps one round of applause because there are 6 speakers. I'll introduce them and let you know a bit about who they are. On the far left in the room, we have Jordan Carter, who's joining us from AUDA and is an Internet Governance and Policy Specialist. Anya Gengo from the United Nations Internet Governance Forum Secretariat. And that is I've just met the speakers. Bo Young is joining us from the Korean Internet Security Agency, and Bo Young, good morning, is joining us from online. Noel Francesca de Guzman, apologies, from the Internet Society is sitting next to me here. Warm welcome. We have Paul Wilson from APrIGF. Many of you will know him. Paul's been a long-standing contributor in this space. And joining us online as well, please welcome Amrita Chowdhury from the CCAOI, which we know as an internet advocacy organisation in India. Please join me in welcoming our panellists. The way we're going to run this is I'm going to hand to Jordan in just a moment and he's going to set some context for the next 50 odd minutes. Each speaker will then get 4 minutes and we will then open up to Q&A from both in-room and online. And I'm also going to give panellists a chance to summarise in 1 minute, would you believe, at the end. So that will really force them to be specific. So Jordan, without further ado, I'll like to hand to you to set us some context, please.
Thank you, Sandy, and good morning, everyone. Kia ora koutou katoa. My name is Jordan. I am from the AUDA.au Domain Administration, Internet Governance and Policy Director. And you know, one of the organisers of this session. This is about evolving the multi-stakeholder model of internet governance so that it can do what the label says for this event, help support the Asia Pacific work through the next phase of the internet. And it is changing. I think we can observe that there will be ever more internet all the time, everywhere. You know, the satellite extension of connectivity means everywhere we go, we'll be able to be online. More and more people will be in the online world. And the internet will be having a deeper impact in our economic, social, and cultural lives. And we know also that new stacks of technology and applications will continue to be built on top of it. You know, the AI craze that's going on at the moment is a single example of new technologies that depend on the internet infrastructure to reach the people who want to use it. And so the internet governance system needs to adjust in response to these changes. And there are other forces driving changes as well. So I want to sort of provoke us all to think about a few points. These are generally derived from the Internet Governance Roadmap that AUDA published a few weeks ago, which one of my colleagues will probably be able to pop a link in the chat. But if we think about those bigger problems of digital governance, if our internet governance system can't solve them, doesn't it mean we need to grow some new institutions that can? Or does it mean we need to change internet governance so it can tackle these questions? For internet governance, how do we broaden and deepen effective participation, both so it can actually deliver, so internet governance can do what internet governance needs to do, but also that it can be and be seen to be more legitimate than it is today? And how can we develop as a community in this IGF, in the global IGF to come, how can we develop a shared sense of how we actually want this model of internet governance to change? And it's timely to be talking about these things now because there are some global processes going on that could change the underpinnings of the way internet governance works. I'm talking about the WSIS Plus 20 review coming up in 2025 and the Summit of the Future with its Global Digital Compact stream that's coming up next year. The ministerial meeting to set the political direction of the Global Compact is about 3 weeks away. So it's a good time to be talking about this. Governments endorsed the current multi-stakeholder model of internet governance at the WSIS in 2005. And they endorsed it again subsequently, most recently in 2015 at the WSIS Plus 10 review. But there's no guarantee that they will endorse it again. What governments gave, in a sense, governments can take away. And so if we want to shape what they're going to do, we need to argue our case that an open, community, multi-stakeholder driven model of internet governance is the one that we need. I think it's the best one because of what it has delivered and because it makes sure that all of the key stakeholders get a real say in shaping the internet's future. But it isn't perfect. This model hasn't delivered to everyone's needs. It hasn't been a system where all of the necessary voices are heard. So that's why it needs to be improved, why it needs to change, to develop, and to grow. And those of us who support this model need to listen deeply and carefully to those who do not support it. Because it isn't simply the case that people who don't think multi-stakeholder is great are wrong or silly or haven't thought about it properly or are just being annoying, which is the way I heard it described once. They have reasons for their stances. There are reasons that some countries prefer UN systems, and there are some advantages to those systems. But I just don't think those advantages outweigh what we've got today. If we fail to renovate and build the legitimacy of the next version of a multi-stakeholder governance system, the alternative is United Nations diplomats in the bubble of New York doing it for us. I don't know about you, but that doesn't leave me feeling very confident about the future of this system, which is so important to our communities all around the region and all around the world. So we need to argue for and articulate an inclusive system of internet governance and cooperation, I think is what Paul might call it. And I hope that we do some of that work today in this session. Thank you, and back to you, Sandy.
Thank you, Jordan. We've got some wonderful context to kick us off. The way I'd like to run it is we're going to go in-person, remote, in-person, remote, and alternate that way. And we'll kick off with Anya. Would you like me to time you or give you a 4-minute warning? Or you time yourself? You're okay?
You can time me, yes,
Okay,
and interrupt me. It's not my skill to be brief. But yes, thank you very much. Thank you very much. And I hope you can hear me well. It's a great pleasure again to engage in a dialogue with all of you and wonderful colleagues that are on my left and right side, also online, on this very important topic. And maybe I can start on a point of change. So in preparing for this panel, I looked a little bit through archives of the APrIGF, which is the office that serves the project where I work. And if you look at 2006, then you will see that the APrIGF at the time was announced by the Secretary General Kofi Annan. And Mr. Secretary General at that time called the internet as the greatest, I'll maybe quote, agent of dramatic change, and maybe the greatest instrument of progress. The overarching theme at that time was Internet for Development. Today, almost basically 2 decades after initial visits and going through 18 years of the APrIGF, we still speak about similar concepts. We may not speak about the development as such, but we speak more about sustainable development, which means that we're more focused. We still speak about the internet and digital technologies, related services and tools as a great opportunity for all of us to thrive and to have basically better lives and to reach the sustainable development. So in that sense, we haven't seen that change, but where we are seeing really a change are, first of all, the governance models, the governance framework. At the time in 2006, there was the APrIGF as the very first forum that put together, just as the announcement at the time said, 2 different blocks. One is more formal, government, member states led, with the non-governmental sector within a traditionally multilateral intergovernmental organization. Today, multi-stakeholder model is much more present also within the UN system as such, but also broadly speaking. And speaking about the point of bubble that Jordan mentioned, I can share the experience of the APrIGF Secretariat. As we speak from that quote unquote bubble, in Geneva with, for example, missions, more and more we speak about the concept of the national APrIGFs and their participation in a multi-stakeholder framework in their countries. And that's probably the biggest change since 2006, more than 160 national and regional APrIGFs, and the application of the multi-stakeholder model, not as mandated by someone for a particular group of people, but really organically emerged and applied on a local level by people for people. And I think nothing speaks in favor better about the brighter future for the multi-stakeholder model, for preserving it and maintaining it, just as processes that you are running here. And I hope that maybe on that note, we can continue later. Certainly, the Global Digital Compact is something within the United Nations system that is gaining momentum. It's been welcomed by the member states, but also by other stakeholder groups. And many of you will know that within the United Nations, many multi-stakeholder consultations were placed to understand what different stakeholders think before the member states engage in a process to bring clarity on what the GDC will be about and if it will be agreed. Thank you.
Thank you so much. Perfect start to the session. Thank you. Appreciate it. Bu-Yung, would like to hand to you and welcome.
Hello, good morning. This is Bu-Yung Kim. I'm working for KR League Policy Team in KISA, Korea Internet Security Agency. Today, I'm going to share how Korean government supports internet governance in local and globally. The Korean government places a great emphasis on the importance of participating from various stakeholders in internet governance and is actively support diverse group and activities. We have Internet Address Policy Committee and the Korea Internet Governance Alliance consisting of various stakeholders, including civil society, industry, academia, to facilitate policy development and vibrant discussion related to internet governance. Also, KISA supports holding KR-APrIGF annually to provide an open platform for discussion on internet governance issues. KR-APrIGF started in 2012, so we have like more than 12 years now. Second, to enhance the understanding of the essence and value of the internet among future generation, KISA organized each project floor more systematically from school to the real field. We call it as the STP-based Internet Governance Capacity Building Program, which is studying at school, training with experts, and participating in real fora. As a first step, KISA developed the Internet Governance curriculum and textbook that can be used in the school, in the university. Students can acquire theoretical knowledge through Internet Governance curriculum at school and share their idea with the peer through the research lab and youth group. And KISA also supports fellowship program for youth to experience APrIGF, IGF, and ICANN. This is the third year that KISA supports Internet Governance Research Lab, which is called as EG at IG Expert Group at Internet Governance. This year, we have over 40 students from 8 universities. We encourage them to study first at the school or research lab so that they are ready to fully experience in APrIGF when they finally meet people from other regions. Also, together with the professors, KISA is developing specialized teaching material for university course. This year, we will publish 3 series of books. First is Internet Governance Principle. Second is Freedom from Digital Surveillance. Third is Directions for Literacy Education on ChatGPT in the context of Internet governance. We will make a series of books that can contain the today's issue. And also lastly, since 2016, KISA has been hosting APrIGF, Asia Pacific Internet Governance Academy, in collaboration with ICANN. APrIGF is the capacity building development workshop focused on the internet governance that is targeted at youth leaders from Asia Pacific region. Over the past 7 years, more than 340 individuals have completed the program, and 25% of students are actively involved in internet governance activities across the region. As a government workers, I will keep working on raising awareness of internet governance for the broader group. Thank you.
Thank you so much, Bo Young. We will pass now to Noel.
Guys, very quick. Oh, is this on? Is this on? This is on. So let me time myself. Okay. So Jordan had posed some compelling questions. So I thought I'd have a go at speaking to, well, one of them. I think that's all time permits. And point to so Jordan asked whether we might be needing new processes and new institutions to address maybe emerging issues. And I would like to point to several initiatives that are rather new that are doing that and are making an attempt at being multi-stakeholder. So one example is the Freedom Online Coalition, and we have another example closer to home, which is the Christchurch Call initiative, which Jordan is also involved with. So I'm going to speak a little bit about the Christchurch Call because that's the one I'm more familiar with. So the Christchurch Call was set up following the Christchurch terrorist attack in New Zealand back in 2019. And it was initiated by governments. So it's actually, in a way, government-led by the French and the New Zealand government. And since then, I think as of the last count, there's like 58 governments participating. There's an increasing number of service providers, including the platforms that we know that are there. And there's an advisory network that's made up of civil society and technical organizations. So this is one example of a new kind of mechanism that is set up to address an emerging concern, which is the spread of terrorist content online. And it has teething problems. It's quite new, but it is somewhat making progress towards what it wants to achieve. creating crisis protocols, for example, that are now in use. This is just to point to kind of examples that it is possible, it's still possible for us to get creative in having new processes that would address emerging concerns without everything having to go under the auspices of the UN. Of course, it's possible to, we need coordination to avoid duplication of efforts for one, but there's that as well. So there is other things to explore. So I'll stop there. I think I'm almost time up. Yeah.
Excellent. You're leaving plenty of time for discussion and questions. So I think at this point, we'll hand over to you, Paul.
Sure. Thank you. Good morning and good day to everyone in the room this morning. Thanks for being here. A useful place for me to start, I think, is to talk about a recent blog post about the GDC, the Global Digital Compact, that was published. And the headline chosen by the editor was a top-down attempt to minimize the role of the technical community, which was pretty blunt, actually, but kind of accurate in terms of what we were talking about. I joined and co-authored that one with Sally Costerton, the interim CEO of ICANN, and John Curran, the CEO of ARIN, which is the equivalent of APrIGF in North America. And you can find it on the ICANN or APrIGF websites and read it in more detail, but just briefly, the point was to respond to the UN tech envoy, Amandeep Gill, who's produced a policy brief proposing a new digital cooperation forum. And he advocates a new tripartite model for digital cooperation with just three components, which are the private sector, governments, and civil society. And he mentioned this at the EuroDig, European Regional Internet Governance Dialogue meeting earlier this year. And we felt a strong need to not let it pass without comment. The problem we have is that the technical community is missing. And in fact, the tech envoy suggested that it is incorporated into civil society. And so Sally, John, and I wanted to address it, not to let it pass, because it's very clear that we absolutely support civil society as an integral component of the multi-stakeholder system. But we absolutely don't believe that the tech community can be simply absorbed or regarded as a part of it. In terms of history, in this blog post, we referred to the agreements made at WSIS, the Tunis agenda, the WSIS plus 10 review, where all of the different recognised stakeholders and their roles, including the technical community, were recognised by the UN. I always like to point out that the multi-stakeholder system was not invented by WSIS, by governments, by the Working Group on Internet Governance. It was discovered by them. It was discovered as they looked at what was the success of the internet and what was the key to the success, and the multi-stakeholder model, as they documented it, including its stakeholder groups, was identified as a critical part. It was a discovery, not an invention. And so that was continued through, of course, the IGF itself, which recognises the technical community very seriously through the allocation of seats on the advisory group, amongst other things. So I guess some might think about or wonder why we need to go back to a history of 1 or 2 decades, nearly 2 decades, to still today. And I would say we absolutely do. It has been nearly 20 years since WCIG. And in that time, the internet's grown from well under 1 billion to well over 5 billion users. Jordan was speaking about this. That's just one measure. There's been a growth of applications of social media, of e-government, e-commerce, bandwidth, the sheer volume of data. The overall value of the internet to individuals has increased massively. And I think the multiplication of the internet success was successful back in 2003. Then it's the multiplication of that success since then. It really is inestimable. And as Jordan said, that's going to continue. Most recently, I think an undersung success of the internet was to support the entire global COVID response and recovery. we took the internet for granted in spite of really unprecedented pressure for its performance and growth and availability. And that the fact is it supported a global societal change towards remote work and education. And I actually feel it deserves a Nobel Prize for its performance through that time. The point is, all of this happened, this last 20 years happened under the continuing and evolving, but the current multi-stakeholder system with the technical community and civil society as essential, recognised critical components. And so I think the burden of proof and justification for a fundamental change, which was certainly not an evolutionary change to the internet governance system, really must be heavy, and we don't see that. The internet and its uses are going to continue to evolve, probably even faster. And we do have to reflect on how the multi-stakeholder approach needs to adapt, but we'll insist that the technical community has and will play a critical role in that. And for the GDC to achieve any success, it needs to really embrace and commit to a multi-stakeholder model that has been documented, recognised, proven, and that frankly, many of us have fought to develop, preserve, improve and protect. And changes to that beyond consensual evolution really do deserve scrutiny that needs to be transparent and inclusive, and not handed down from the top as our editor described it in the blog post. That's all. Thanks.
Thank you. Thanks very much, Paul. Amrita, we know you've got a couple of technical issues, but I think you're back. If you do drop out, no problem. We can go to Q&A and I can bring you back again. But let's try and hand over to you, Amrita. Thank you.
Thank you so much, and I hope I am audible. And I would like to respond first to Jordan's question that do we need another platform? The thing which we are looking at is we are witnessing a growth in multilateral and multi-stakeholder platforms for discussion, but unfortunately most stakeholders cannot take part in many of these forums and do not have a voice. Typically the example of GDC, which is supposed to be a multi-stakeholder discussion, but the multi-stakeholder is also defined as per UN terms. There are questions about where all a stakeholder can participate, because it is after all the nations who would be deciding. Where would civil society be speaking, or where would be technical community speaking? And if you look at the process, most of the countries are also not having the discussions within their fora. So it is important. And if you look at Asia Pacific, not all countries are at the same level of development. So the conversations need to happen, even if they are different at different levels. The requirements of countries and the people are different. So there has to be platforms where such discussions happen. And rather than reinventing the wheel, the IGF, which is a UN-created structure where we have different stakeholders coming and discussing, and even the NRIs, for example, APrIGF could be a point where such discussions happen, because discussions can happen freely. These could be a sounding board for even any kind of structures, any kind of more developments which are needed. For example, the IGF is not perfect, but the EGM, which had happened last year, March, had some points which were, recommendations to improvise the IGF. So IGF could go to the next level, version 2.0 or 3.0, with certain changes, and it could take care of a lot of things which the new Digital Cooperation Forum aspires to do. So I think rather than reinventing the wheel, it would be worthwhile to upgrade the existing structures to perform better and address more issues. So I will stop at there.
Thank you so much. I think that's given us plenty to think about, and we have quite a decent amount of time for audience participation, questions. So those of you online, I can see a question coming through now, but I might encourage any of you in the audience here to raise your hand. And I will kick off, I think, with Kylie, who's posted a question online. I know she's encouraging questions to be posted online. So there you go. How about anyone in the audience? Would anyone like to kick off the conversation? We have a question from the gentleman with the yellow hat on, and we have a roving mic. So we just wait. And if you could let us know who you are and where you're from, that for the record, that would be great.
So my name is Alexa Pendoshte. At the moment, I'm the acting president at Linux Users Victoria. This is more a general question that in IGF, do we make conclusions or intentionally not making any conclusion about the topics that are discussed? Is IGF in general a forum for that, including this topic?
I think that was, if I try and interpret, I'm thinking about the idea of a forum for decision makers, not decision making. So there's more dialogue and discussion versus outputs. Is that where you were going with that? And could we comment on that?
Thank you. So it's a very interesting conversation. And I'm wondering whether this opens up a discussion that if I know people who have comments later, they can put their inputs in and then the conclusion is made further down the track, or IGF discussions are for concluding those discussions that have been happening prior to that.
Thank you. Thank you very much for the question. I actually like the term you're using, not decisions, but conclusions. And I think there's a difference. The mandate of the IGF certainly is not to make any decisions. It's not a decision-making forum. It's a forum where all stakeholders as equals will engage in a dialogue on the issues they find relevant. But I think, yes, you are very much right. There needs to be a point after rounds of discussions and dialogues. And certainly the IGF tries with its stakeholders to ensure that there are concrete outputs produced at the end of an IGF cycle through various streams. So for example, that means also through the intersessional work, but also at the annual meeting following the reporting of all session organizers, we're looking through thematic tracks what has been said. So what are the points that are emphasized in terms of the agreements, disagreements, what could be the potential way forward. So that's something that the IGF has been working for the past couple of years, especially to ensure that it is action-oriented, but also output-oriented. And maybe visiting the IGF website, you can see the nature of those messages. It has its evolution, just as the digital technologies and the narratives around applicable policies do have their evolution, and I think definitely it will continue evolving. And it's very much dependent on what you think it should be, and including the form on those conclusions you mentioned.
Thank you. Well, we'll go to Paul, but just to let Marita and Boyong, if you want to participate in the conversation, I'll look to you. I don't know if you can see me looking to you, but raise your hand so I know to pass to you. But we'll pass to Paul, and other panelists, please feel free to just riff on a previous panelist.
Yeah, thanks. It is a good question. As a past member of the MAG, the Multi-Stakeholder Advisory Group at IGF, I well recall a lot of discussion about outcomes, outputs, what is the legacy from each IGF meeting that can be handed on, etc. And I just, so it's an issue. It's been an issue across the entire IGF system, I'd say, that's been tackled in different ways. But I just wanted to mention particularly here that one of the innovations of the Asia Pacific Regional IGF is what's called the synthesis document, which is a collaborative, collective effort, and it becomes an output from this meeting that's discussed in the town hall sessions at the end of each of the days. So you may have seen some of those sessions, but that document is open for contribution, for editing, not just during the course of this week, but for some weeks afterwards. And that becomes the important kind of artifact from this meeting as a collective consensus synthesis of what's gone on in the past few days. So I would encourage you to take a look at that. Thanks.
So the question there is, can we take that document proactively back into our community groups and other organisations?
Of course. Yes, that is the point. Thank you.
Thank you. And Rita.
Yes, thank you. And just adding to what Paul mentioned, this is a criticism that IGF always faces, that there is no straight cut recommendations which comes out, but messages, reports, etc. However, it is a double-edged sword. Many governments and many people may not speak openly if you have concrete solutions coming from, because there would be a chance of slight censorship from certain governments of what messages come in. So I think having platforms where you can have more conversations and having messages coming out may make sense.
Thank you. We have no questions emerging in chat. I can't believe this. We have a question right up, the two questions, excellent, right up the back. Just state your name, please.
Hello, I am Deborah from Tika Foundation in Indonesia. So based on I have to make a disclaimer, amateur observation on internet governance, I have a lot of concern regarding the lack of awareness of the dangers or the adverse impacts of internet fragmentation on the side of policymakers, governments in our country. So my observation is there's a lack of awareness of what internet fragmentation means for access to internet, and also the use of internet in our country on the side of policymakers. What I would like to understand is how have multi-stakeholder forums like IGF, for example, but also multi-stakeholder governance mechanisms which are implemented like in forums like ICANN, like RIRs and so on and so forth, inform the government in their language about these impacts on the global connectivity. Because the trend, as we can see right now, is that internet fragmentation occurs at different layers of internet stack, not only the legal, not only at the legal layer, but also a lot of the shutdowns. For example, we can say that a lot of internet shutdowns are part of efforts from the government to conduct internet fragmentation at the technical layer. And this has been conducted in recent years, even without court adjudication, for example, and this has been a trend. So I wonder, how have multi-stakeholder forums like this been useful in informing policy makers about these issues? Because I feel that it is just the technical community and civil society which are aware about these and are concerned about this. Thank you.
Thank you. I wonder if we kick off with Noelle, and by all means other panelists build on.
So I can speak a little bit about what's going on in international fora. And then maybe what the Internet Society is doing, because we are doing work on fragmentation currently. So there has been some increased take-up and awareness of fragmentation, including in multilateral fora. For example, the outcome document of, so the declaration rather, of the digital ministers this year at the G7 explicitly referred and opposed internet fragmentation. But I think one of the challenges in stakeholders rallying around or against internet fragmentation is the lack of consensus of what internet fragmentation is, and whether it's desirable or not, because some stakeholders do think that to some extent it is desirable. So what the Internet Society has been doing is, rather than define what fragmentation is to take a use case approach to fragmentation. So how does it manifest concretely? Through regulation, through policy developments, etc. And we have a framework called the Internet Way of Networking framework, but also a toolkit for assessing what the impact is of a certain event or a certain policy development to the internet, and the qualities and the principles of the internet that we would like to foster.
Yes, I could just very briefly, basically, I can just confirm what Noel said, but the concept of internet fragmentation emerged in the past 2 years, especially in the discourse of the IGF, and we've been addressing it through a dedicated institutional work stream. It's called the Policy Network on Internet Fragmentation. And I do understand Deborah's concern that maybe you see sometimes these discussions as dominated by non-governmental sector. But in fact, it's not. When you look at the statistics, especially participation statistics, when you look at the composition of the multi-stakeholder advisory group, of the leadership panel of the IGF, participation in that policy network on internet fragmentation, then you'll see there's a solid balance between the stakeholder groups. Of course, civil society is just speaking from a multidisciplinary point of view, the largest group, and it just gathers most of the disciplines. I think that's just reasonable to expect. But we do have a good cooperation and good participation from the majority of the member states. So at the IGF, you have stakeholders coming from around, on average, 160 or over 170 countries. Many of them are governments, and they do listen and they do participate. So that's the purpose of the IGF, actually, to share good practices, to inspire policymakers to make informed decisions. What we are focused in the past couple of years, since 2019, is the legislative part. So the legislators, we are seeing that the regulation has been changing quite a lot in terms of the landscape. Concrete laws, rules of behaviors are emerging. If you look at the AI, we now have some statistics say over 40 countries having national legislation or introducing it. Just 5-6 years ago, we spoke about the very few. So things are very much changing, and we really need multi-stakeholder discussion processes for a dialogue before these decisions are made, because that may lead us to risk of fragmentation from a normative point of view, that you have different way to regulate something that is transnational and just of global nature.
Thank you. Paul, there's a question online that I suspect is directed at you. Did you want to make a brief comment there, or can I go to this technical question?
I'd like to make a brief comment about fragmentation.
Yep.
It is a very difficult term. It's one word for many different things, which is fine, but it means that if we want to be practical about fragmentation, what it means and how to address it, we've got to be quite specific about what we're talking about. So I think everyone has got some idea of the internet being divided into multiple layers, and there's an infrastructure layer, there are applications, there are even regulations on top, and you can have fragmentation for better or worse at any of those layers. You can have fragmentation at different times, geographically specific or not. It really taken as a whole, it needs to be seen as a quality or a set of qualities. In fact, there can be some deliberate fragmentation, particularly at the technical layers, for the sake of efficiency and operation of the network. But I just wanted to point out that I think this is a good example, if I need to say a little more about the concern about civil society and the technical community, is that it's about the layers. And the internet for the technical community was always the internet layer, the infrastructure layer. Quite specifically, an internet address is an address within that infrastructure layer. And that's really where the technical community does its work. It's about making sure that traffic can go from point to point, that domain names can be resolved, that standards can be developed within that internet layer that serve applications and applications of and functions of the internet. And so that's one view. A broader view of the internet is kind of everything, and it's a very important holistic view that tends to be a more civil society view, or the view of governments and civil society, and it is a different internet. The fragmentation that we're talking about in those two internets is a very different thing, and I think that, sort of practically speaking, is one of the reasons why we don't feel that you can put all of this stuff in one room, in one bucket, and try and sort it out. That we do need some texture and structure in the system. Thanks.
You may have addressed a little bit of what Jean online has posed, and that is regarding the neglecting of the technical community. Has there been any stated reason for this proposed change? And does anyone suspect any different real reason for the proposed change? Thank you, Jean.
No, no, and no.
No and no. Jordan.
Could I just add a couple of thoughts on that? Shortly after the blog post came out, there was the Amandeep Gill was speaking at the Caribbean IGF, and he used quite different language, which was an interesting shift towards a more multi-stakeholder point. But one thing I want to say about this around the neglect of the technical community is we keep, if Paul sort of made this intriguing contribution before that the governmental system discovered multi-stakeholder internet governance, it didn't create it. And that was at the time a compelling story that they bought into to leave it alone. And it may be that we now need to tell that story again. But if we're going to tell that story again for the 2020s, the technical community needs to be a leading voice in telling that story. And it's wonderful that you and Sally and John collaborated on that blog post. It would be much more wonderful if a few other IR leaders' names had been on it, and if ISOC's name had been on it as well. Because 10 or 15 years ago, you'll remember the Montevideo statement process. A vibrant, deep-seated, engaged collaboration between the leaders of the technical internet community meant there was a shared set of ideas and arguments available to advocate for the open internet and also to shape the governance framework. And I want to make a call out to encourage and welcome your role in having started doing that here, and to shout out to anyone from those other organizations who's listening to get on that train and get collaborating again, because we need to be making that case in these UN processes as brightly and positively and effectively as we did 10 or 20 years ago to keep the opening for our community. So we can be annoyed that they seem to be trying to abolish us, but let's tell the massively positive story about why it's great to have us in there and what we can offer.
Thank you. I think we had another question up the back. Did the woman want to? Oh, got one down the front. Oh, no, where am I? Where am I going? Oh, sorry, he's at the microphone as well. Oh, I was, I was going in order, so I apologize. We should have gone there, but we'll go you because you're right in front of me.
Thanks, Alex.
Please.
I actually wanted to build on, let's say, the point that that Paul and Jordan were making is that when you listen to the conversations here, and I'm very glad we're having the session kind of towards the end of APrIGF, I think it also begs the question of what do we consider still internet governance? Because I mean, I was taking a little bit, let's say, taking notice of, let's say, your opening remarks, Jordan, where you said, I don't want UN diplomats to talk about internet governance and kind of design things for us without our input or our consideration, which I think is a fair point. Which is a fair point if you consider, I think, internet governance to be really about how to protect kind of that core, almost kind of the technical layer of that internet. But if you look at internet governance and all the topics we discussed over the past few days here, I think you cannot but agree that there is a role for the multilateral system. When you talk about sustainable development goals, that's a UN multilateral initiative. So I think that brings me to the point that I think multi-stakeholderism is kind of a blessing and a curse in and of itself. Because yes, it's a blessing when you want to, let's say, create that rough consensus and you want to, let's say, get the community behind some of the technical, non-political things. But it's a curse if that becomes kind of a place where you can kind of discuss everything and all related to the internet, which I think is a situation where we're kind of landing at the moment here in the region, here nationally in Australia, but also globally. So do we need, let's say, to go back to kind of what's the core of what we mean by internet governance or governance of the internet? And does that also require this community to be more selective in what is within scope and what's out of scope? Because if everything is within scope, you cannot exclude, let's say, the big bodies of the UN, where lots of, I think, countries represented here today have great stakes in there from that conversation.
Thank you. Who would like to kick off? I'm just checking with Amrita and Buyang. Let's start with Amrita.
Thank you so much. And that's an interesting question. If we look at how technology and digital is, it is cross-cutting. Internet governance was just limited to technology, but today, since everything is cross-cutting, there is overlap. So yes, these forums need to discuss a lot of things. If you're discussing sustainability here, doesn't mean that UN has no role, because that was a mandate which came in. But at the end of the day, it is all the stakeholders who actually have to deliver or buy in to those, whatever the governments have decided, else things will not run. Just mere governments would not be able to do so. So multilateral would definitely there, but multi-stakeholderism also has to involve, primarily because many times when decisions are made at the UN level, you will see blocks of countries. It is also political. And many times even the citizens of the country itself may not have the buy-in. So if you want something to work, or if you want a nuanced approach, even countries need to take in what the ground level realities are, or what people think. Simple example, rules are made for children, but children are never considered. In many countries, rules are made to protect women, but no women are there in the panel. So if some multilateral forum is making decisions on our behalf for citizen welfare or business flourishment, the business or the citizens or even the technical community needs to be there. So you can't have a 0-1 game. There is a gray area, but I think both the systems have to thrive, but you have to understand what is happening at the ground level. And for that, you need the multi-stakeholder with the good, bad and ugly.
Noelle and yeah, we'll go Noelle and Jordan, then we'll bring this to a close.
Thank you. So a few things. I think the points that Bart raised are valid. So a lot of, I mean, to be very blunt about it, a lot of users don't care about the internet, the technical infrastructure. They care about the services that they interact with. And a lot of our discussions, if we want to be inclusive, that would mean addressing what people are concerned about. Our concern at the Internet Society when it comes to multilateral bodies is scope creep. So when it comes to content regulation, for example, there is now suggestions of interfering with how infrastructure providers operate. So for example, asking Cloudflare to be involved in blocking specific types of content, which it cannot do. It can block, swaths of IP addresses, which would not be good for any of us. And in our involvement in UN meetings, we have, we feel like we are constantly pushing back against the UN just trying to have its hand on everything. But I agree that we shouldn't include them. We shouldn't exclude them, rather, even in technical discussions. And so in Internet Society, for example, we have a policy track at the IETF, because we do feel that they should be aware and they should be involved about, well, at least they should understand how standards are developed, because that's a way of engaging with them. And that's a way of making them aware that, these are the processes in place and they work.
I'm trying to be really quick, but it's a good point to raise. I think one of the things I keep remembering is that internet governance, multi-stakeholder fashion, does include governments, and they are an essential part of the mix because they have to then go away and legislate. So that we want them to be informed by these processes. It's not a matter of leaving them out. And it's also inevitable, though, these broader digital governance questions that governments have to get involved, because often they need to be solved by regulation and legislation, and because there are really tricky decisions about what the public interest is. And that's absolutely the territory of governments to define that on behalf of the people who live in their countries. What we need, I think, in the system is enough attention on the technical layer to make sure that it can keep developing. And a great way for the insights of that technical layer to be brought into the broader digital policy space without losing enough focus on the technical side of things. It needs to be a two-way flow. The technical dialogues and the policy dialogues need to inform each other, which is sometimes what the IGF system is helpful to deliver, but it also needs to deal with the technical governance questions.
Thank you, Jordan. We need to start wrapping up. So I'm going to ask each of the panelists to give us their sort of closing thoughts. And if I can be a little provocative, I think we we all acknowledge that the multi-stakeholder model and the systems and processes that all of us in this room do fundamentally believe in, we all acknowledge that the model's under threat. I think many of us have acknowledged that we'd prefer to keep the ones we've got and iterate and improve and evolve. But I would like to provoke us into thinking, how do we move beyond acknowledging towards action? And each of the panelists have got some thoughts, I suspect, on how do we move into action. Paul's already spoken about raising awareness through the blog. And so I'd like to provoke the panelists in thinking about that and give each of you literally 1 minute. And we're going to go in reverse order. So I'm going to start with Amrita, and then we'll just without me intervening, hand to Paul. So Amrita, over to you, 1 minute.
Thank you. So what we would suggest is have more conversation. That's one, within the region. That's important. Second is, if, for example, taking the GDC and if we want the IGF to move to the next level, perhaps we need to look at what the recommendations of EGM are and see if it can, take care of the digital cooperation from what it is aspiring, and, make that transition and show it to the co-facilitators or others that, look, this is a platform which can take care of what your concerns are with these changes. Thanks.
The technical community doesn't feel neglected. That's a sort of emotive word. We don't need approval, but what we think is very important is that the technical community is understood. And I'm not just talking about a few organizations here, I'm talking about communities of thousands of professionals and thousands of organizations, those who have built and continue to build and run the infrastructure. So it's important that be understood. And I want to say again, I see the same importance in civil society. There's not a hierarchy here. One of the things that I really appreciate Jordan's point before about the Montevideo statement, which was a rare kind of coming together in an impactful way by a group of very different, diverse organizations. But I think we do need to do more of that. And we also need, I think, to have some more inter-stakeholder dialogue. And just today started to talk about the possibility of technical community, civil society coming together for more mutual understanding across that divide of positions and priorities and so on and so forth. So there's not a sense at all, and I can say here and now, there's not a sense of priority or value, but just of understanding and appropriate structure. Thank you.
Okay. I do feel, and I don't think I'm the first one to say this, that we need a compelling narrative. We need a concrete vision of where we want to get to with internet governance, especially with all the issues that are surrounding us. And we do have frameworks in place to guide us and to ground this vision. And of course, the one that I can think of is the one that the Internet Society produced. I'm so sorry. So that is, we have what we call the Internet Impact Assessment Framework, which is a toolkit that's available in the website, in the Internet Society website. And basically, it articulates the principles that underpin the design of the internet and the processes that govern the internet, bottoms up, decentralized, etc. So it gives a strong rationale for these processes and for these principles as a kind of a very basic necessity for preserving the value of the internet for future generations. And it also gives us something to aspire to. So when we talk about open, global, secure internet, what do we actually mean? So part of this framework is actually to qualify what makes the internet open. What are the qualities that make the internet global? So I invite you to please have a look, and maybe that's one of the starting points that we can use.
Thank you. We will go to Bu Young and then to Anya.
Yeah, lastly, I would like to share that KISA as a member of APTLD, which is another big part of the technical community, and also as a host country of the coming members meeting, proposed to release the member statement on how CCTLD registry can contribute for the future of the internet. This statement is developed with several CCTLD registry and also includes the needs for the capacity building for youth and policymakers and civil servants. I think sharing what we learned from how we start the internet infrastructure layer is very important to shape the next phase of the internet. Thank you.
Yes, thank you very much. I think this community worked hard for the past 2 decades to create something that was probably unimaginable to the majority 2 decades ago. And my message would be to continue nurturing and owning that sense of ownership and belonging to a network for something that you worked hard. And yes, maybe the decisions are made by few, but checks and balances are with you as a collective force through the mechanisms that you've created. And nurturing the stakeholder engagement, strengthening it through the national, regional IGFs, through various capacity development initiatives that exist, globally speaking, is probably the best way for us to spend our energy to make sure that we have a say in what the internet governance or digital cooperation will look like now and tomorrow.
Really quickly, 43 seconds. I endorse Paul's point about inter-sector collaboration. Technical community and civil society have done great things together. Sharing perspectives and helping shape this governance debate together is a really strong point. The other thing we can all do is talk to our governments about these UN processes and emphasize the importance to them of keeping a multi-stakeholder approach to internet governance and urging them to get the UN processes to be more open and inclusive as well, so we can have our voices truly heard in that debate. I think that's some things we can follow up with.
Thank you so much, Jordan. We've got 7 seconds to spare. I just think that's magical. Thank you, panelists. You've just done an amazing job. I hope that particularly the last bit or the whole bit, but the last bit has really sparked some ideas in you around how can we progress this? How do we take action? I don't even need to summarize because it's kind of all been said. So I'd like each of us to say thank you very much to the panelists for their participation today, and thanks very much to the audience. I was going to run over a bit. Morning tea? Yeah, I'll send you have more than 40.
Recording stopped.
Hello, Audrey, can you hear me? Are you able to test your audio, please?
Hello, this is Audrey. Can you see and hear me? Testing.
Yep, excellent.
SDG 1, 2, 3.
Thank you. Great, we can hear you. Thank you very much. And Benjamin, if you could test your audio, please.
Hi, this is Benjamin calling from Singapore.
Excellent. And KC, we'll get you to test your audio too. No, you're still muted, please. If you can unmute.
Okay, this is KS testing.
Excellent. Thanks, guys. It's all working. We will be starting in about 5 minutes. Thank you.
I didn't want to give this warning because I don't have for all 8 and staff. I guess that was Sylvia, you and Pablo. Are they gonna come, both of them? Yes, for the clovers. Okay, so I'll see them. Okay, good then. Okay, I'll see you later.
Can Ben hear us?
Hello, I'm just testing that you can hear us when we talk from the room. Are we all good? Excellent. And thank you all. Brilliant to see you. I love it. Thank you, Audrey. Great. If you haven't worked out, I'm that Cheryl Langdon or part of the equation. Hello, Kaspark. How are you, my friend? It's been a long time between working with you.
Ben, I'm very disappointed that you're in Singapore and not in Brisbane. Now
Is
you're
that the
guessing
voice
who's
of
this.
Bart? Is that the voice of Bart? I'm also disappointed that I'm not in Brisbane. Seeing all the familiar faces on the panels and in the Q&As, but schedules, I'm just grateful that we are able to do it hybrid. Otherwise, I'd miss it completely.
That's right.
Yeah. But we have to catch up in person soon.
Yeah, indeed. That was quite a few years ago.
Someone rang the bell outside and they hit me to ring. See if I can get it.
Recording in progress.
Can you find it? It's private age, I just think that to say you ring the bell, please. Thanks.
Can the speakers hear me? So just to give you an idea of what's happening, we're just waiting for people to enter the room, just coming off from coffee break. And as you know, it takes some time. So maybe just a few minutes and then we'll get started. Cheryl will start you off.
That's definitely one of the things that we miss by not being there in person, the coffee break and the conversations that happen.
You're in charge of taking all the great photos, so make it look good, all right? Oh, you usually disappoint me. My next meeting, we always want to take it. When you're getting answers 60 seconds after you're done.
I'll go up and yell.
I hear bells ringing.
Yes,
I hear bells ringing.
but I want bodies in the room.
Okay, go for it. You get it. They are literally ringing the bells out in the coffee area to get the herd in all the rooms. So our apologies, but at least we're ready. We're all looking good. We just need our audience. Okay, I appreciate you all coming in and assembling with as much haste as possible. You can all just gather your seats. Thank you very much, ladies and gentlemen. Okay. Let's roll. Good morning, everyone. My name is Cheryl Langdon-Orr and I'm the on-site moderator for today's session. As you may have determined, our speakers are in behind me. They will be on the main screen shortly. All unfortunately, well, it's unfortunate for us. It's not unfortunate for them having to appear remotely today. But we have an absolutely great lineup of people, which I'm sure you're going to enjoy hearing a little bit from. Now, why am I saying a little bit from? Because this is a town hall. This is not a panel session. You see, you all thought you'd had your last town hall yesterday afternoon. No, 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 no. APrIGF, and I want to recognise Joyce at the other end of the table. She's our on-site remote participation moderator and will be the voice of any questions coming in via the Zoom room. Yes, you all thought you'd had your last town hall, but this is one that we're running as a session. So we do want you to be interactive. We want you to be inspired and thought-provoked by what you will be hearing to three very, very basic questions that we're going to look at today with regards to what can be a deceptively simple or deceptively complicated topic internet fragmentation. Those of you who had the privilege and pleasure of being in the last session in this room, it was almost like a segue. It was perfect. They started to discuss some of the aspects that we will certainly be touching on in our session today. But we're going to be looking at what is internet fragmentation. We're going to look at a little example of some of what internet fragmentation will be. And Dr. K.S. Park, who you will see upwards on the right-hand screen, a very long-standing and very esteemed member representing here, the civil society views in particular, will be giving us a very short presentation that we would then like to have you respond to. We'll then move to a question, which is what does internet fragmentation look like from an internet user perspective? And for that, we will be going to Minister Audrey Tang. She will be kicking us off with that. And I know what she's going to say, and it should get the juices going. So line up at the microphones, put your hands up. We will bring the microphones to you and we'll have an interaction with that. And then we will be closing off with a third question, which is what can we do about this? Is it possible to avoid fragmentation, and how? I guess we could also think, should we? Do we need to? All of those issues will come in the last section of our discourse today. And for that, we're going to look to Benjamin Ang, very much from the industry sector here, and academia is going to be obviously brought to the fore by each of these highly qualified individuals as well. So with that, I'm going to ask them to do any additional intros as they take the microphone the first time. I'm also going to encourage them to interact with each other, but I want to remind you all, I will be stopping, I will be looking to the audience. I might ask you to put your hands up, agree, disagree, take the temperature of the room on things, and I certainly encourage you to get a microphone to you or to come to the standing mic and make your points. This is a discussion, not a lecture. That's my time done. And if we can flash up our very first question so everyone has it in our mind, what we're going to be looking at right now is what is internet fragmentation? And I've asked Dr. Park if he can give us an example or two of fragmentation or the causes thereof. And if we can roll the first presentation, thank you. Over to you, Dr. Park.
Yes. Can someone make me a host so I can share my screen? Screen sharing is disabled. Okay, well, I'll start speaking. So when we talk about internet fragmentation, we often talk about inability to access all the websites from China or Russia. But there is a better example. There's an example that is closer to home, which is sender pay rule that is fragmenting out South Korea from the rest of the internet. As you know, internet is the ultimate crowdsourcer. It crowdsources all the connections. Before internet, you had to pay $2 per minute for international phone calls, sometimes $20 per minute. Post-internet, like now 100 people are on Zoom call for hours for practically free. How is this possible? By crowdsourcing. If you look at these green dots, one way for all the green dots to talk to each other directly is when they are fully connected, like in the middle. But if you take that route, it's just too expensive because as the number of dots to connect increases, the number of connections needed increases by its square. If there are a billion computers to connect, then you need a billion times a billion connections. So instead of doing that, the internet was made possible when every participant, everyone promised that every participant in the network will deliver everyone else's data without charging money, without condition. That way, and data delivery, so that way data delivery cost was made zero. So everyone pays only to connect to the existing internet. That's why you are paying by capacity, not by how much data you used from your home. The only money that you had to pay was that connection fee, which is also called IP transit, to share the information between the networks. The peering was enacted, and that was for free. That made possible information revolution, and that was backed by science, because signals, the signals are made up of electromagnetic signals, which is a light, and light passing through a medium the cost of passing light through medium is almost zero. And if you look at it's like having light go through mirrors. When light ricochet off mirrors, mirror doesn't suffer any damage. That's why over the years of the pandemic, from 2018 to 2021, the network traffic increased like 5 times, but network maintenance cost may remain the same. However, there is a new threat to this information revolution, which is a paid peering and sender pay rule. European Union is tinkering with the paid peering or sender pay, I don't know which is basically bring back the data delivery cost. Now, South Korea has already enacted sender pay rule only among ISPs. It was not imposed on content providers, but among ISPs, where sending data is now financially penalized. Now there is a delivery cost. If you are sending money into the network, you have to pay. What's the result? Well, because sending money becomes unpopular, the ISPs didn't want to host popular content providers. That means IP transit fees, when skyrocketed high, you can see for Seoul, $3.77, compare that to Paris, 45 cents. So like 8 times Paris, 5 times New York, and same thing in 2021, IP transit fees is 8 times London, 10 times Frankfurt, and impact on end users is clear. Big content providers, they obtain volume discount, but small to mid-sized content providers suffer most because they cannot get volume discount. Now, Africa TV, which is one of the, it's like TikTok in Korea, they are paying almost all of their profit as internet access fees. 2021, Watcha, which is a domestic video service, was paying 10% of revenue as internet access fees. In 2020, COVID location announcement system, the system that announces the location of pandemic patients, that was not fully functioning due to high transit fees. Let me see. And let me see. So local video services dropped out of competition against YouTube because of high internet access fees. So since Naver and Kakao, Korea has not seen any unicorn company. And small ISPs are cannibalized by big ISPs because of a high domestic transit fees. Now, it doesn't stop there. Small overseas content providers are refusing to connect directly with the Korean ISPs because the Korean ISPs are now trying to impose this data delivery cost to the overseas content providers as well. and overseas content providers are unwilling to carry or invest in, or they are forced to charge Korean eyeball-heavy content uploaders, or they are forced to intentionally degrade Korea services. For instance, Twitch last year had to intentionally degrade their services to decrease the paid peering fees, basically data delivery costs that they had to pay to Korean ISPs. And probable impact if this trend continues, you can see BTS. BTS became popular by uploading a lot of videos about their daily lives. Now they cannot do that because other countries charge sender pay rule. Then platforms hosting BTS content will have to charge BTS in proportion to the popularity of their content. Same thing, you can see Psy, the singer of Gangnam Style. Gangnam Style is the video that I think is like number 4 in terms of the number of views throughout the history of the internet. And the more popular you become, or the more sought for, or more viewed by viewers around the world, the uploaders will have to pay the ISPs whose customers are the viewers of the content, and that will basically fragment Korea out of the internet as we know it. I'll stop here. Thank you.
Thank you very much, Dr. Park. I really appreciate that, particularly the scary slide at the end. That's got everybody's attention, I must say. Joyce, do we have anything coming in online at the moment? Okay. I was looking around. I didn't see anyone wishing to jump up and suddenly react. Noel, I'm looking at you. Could I ask you to come to the microphone? Because, yes, look at me, Dal. Come on. Yes, you, Noel.
Oh, me.
Yes, you're the one. You are the one I very much want to hear from. And you're the icebreaker for me, because I know I can rely on you. And I also know what you're going to say, which is a good thing. If I can get you to come to the microphone, because from an internet society perspective, you're doing a lot of work on internet fragmentation. So I thought not so much a question, but you might want to share with the audience who perhaps weren't in this room earlier, some of the impact work that is going on. Thanks.
Thank you very much. Oh, this is on. I think my voice is loud enough. And thank God I'm wearing heels today because I'm finally tall enough for the microphone. Yes, so we have worked with actually the speakers and their organizations in trying to kind of map out how fragmentation manifests, and we would like to be as much as we can, to be concrete about how we think it manifests and whether and how it might impact the value of the internet as a public good, a global public good. So we have I think I mentioned this in the panel earlier. What we are doing is that we are collecting specific cases, one of which the sender pays rules that are being discussed. Well, actually, I think now, in a way, it's already being practiced in South Korea, but it's also a very topical issue now in the EU. So it's and it's not a new issue either. But to look at these specific cases and then to outline the specific ways in which they might impact the open, globally connected, secure, and trustworthy internet. And finally, to have some guidance for stakeholders and advocates like us on what we need to do to respond to this, whether this is a good development for us and for the internet, or whether this is a development that may not be good for our uses of the internet.
Thank you very much. And I do appreciate that I did put you on the spot, but you'll forgive me eventually. Thank you very much indeed. All right, let's move now to Minister Tang. So Mr. Tang, if you wouldn't mind bringing some of the end user perspective into all of this. Over to you, Audrey.
Okay, assuming you can hear me, really glad to be here. So for everyday users, internet fragmentation naturally leads to a situation of uneven online experiences. We both connect to the same site from different jurisdictions. We see something completely different. And according to the discussions at the Policy Network on Internet Fragmentation, or PNIF, internet fragmentations that affect user experience can come from political developments, such as content censorship, as well as commercial ones, such as an ISP compelling users toward their preferred services while paywalling the rest. But one example I want to bring today to share with you is something that has a technical motivation. The example is to prevent the spread of malware, so computer virus. And we have implemented as part of the DNS RPC response policy zones in Taiwan by the Taiwan Network Information Center, or TWNIC. Now, the TWNIC manages the .tw top-level domain, but many malwares are not hosted in that domain. And so TWNIC cooperates with domestic telecoms in implementing the RPC, which restricts the access to malicious domain names through domestic DNS operators' participation. Now, all that is very technical and well and good, but this year, Taiwan's e-commerce vendors asked TWNIC to extend the RPC mechanism to defend against fraudsters impersonating their e-commerce websites. Now deployed as the first line of scam protection, the user experience goes something like that. There's an email, we click on the phishing link that masquerades as a popular e-commerce site, but instead of seeing this impersonated website, we see a notice, and I quote, "This domain is involved in fraud cases and has been blocked. If you have any questions, please send an email to 165RPC, end of quote. So the mechanism goes like this. The Non-Store Retailer Association acts as a contact window for reporting. So they must first file a case to the police department, and then they can report to our Administration for Digital Industries, the ADI, which is a trusted reporter in the RPC multi-stakeholder mechanism, to seek a quick response action on fraudulent website domain names to prevent the public from being deceived by phishing and cybercrime and so on. But obviously, and some of you may already be thinking this, the RPC mechanism requires very careful multi-stakeholder governance, transparency, and coordination. Otherwise, even the most well-intentioned mechanism can lead to fragmentation, eventually causing harm to basic human rights, such as freedom of expression and association online. And so we paid extra attention to this concern. Now both the police force and the ADI, the administration, published a list of RPC domains as open data, ensuring quick update by participating DNS providers, of course, but because it's open data, human rights groups can scrutinize them to facilitate appeal processes and also enhance accountability. So this is just a very small vignette, but I hope I explain the user experience of what it looks like from a DNS RPC experience in Taiwan. Thank you.
Thank you very much. And I wondered if any of the other panelists wanted to react to that at all. I'll open the floor to you first. Benjamin, are you tempted to react? If not, it's okay.
Thanks so much, Cheryl. And thank you to Minister Audrey for sharing that example of a very useful form of internet fragmentation. And it's really an illustration of how the internet fragmentation, when it is following a procedure that has checks and balances and that follows due process, can actually lead to benefits that are in line with what the community or society actually wants. And I think those are key elements of how we actually look at this whole picture of internet fragmentation. Back to you, Cheryl.
Thank you very much. Anything out of the Zoom room? What a quiet lot of remote participants have. Now, let me see. Is there anybody wanting to make? Please, can we get a roving mic, or if you would care to... No, we're going to get to the standing mic. Fantastic. And please
Hello.
just...
Good morning,
I was gonna say-
Stella for the record.
Yes, good.
Okay, so from the user perspective, so I'm quite new to APrIGF, but as a user, I think internet fragmentation for me is when I go online on social media and I see a different content from other users. So there's the role of big tech companies, social media companies who are controlling what we see online because they're profiling us every day. So that for me is from a user perspective that we also have to consider in this situation. Thank you.
Just while you're there, is that a good thing or a bad thing? Is it making your experience more selected, or are you
For me,
being exploited?
It's not bad sometimes, but it's leading to harms that we can only realize when we have been profiled for so long, because we are being boxed in this kind of profile that they see that we, this box that we belong in. So we are limited in ways that we can choose, the way that we behave, the things that we know. So misinformation, disinformation spreads. And also I think the right to be forgotten also contributes to internet fragmentation, though I'm pro the right to be forgotten under the data protection law, but sometimes it limits what others know. Because if we exercise that right, we are limiting access to information.
Thank you. And if I heard correctly, I'm hearing a difference between choosing what you may wish to have as a curated set of things presented and just having a profile done, regardless of how that information is sourced, and a curated set of things being delivered to you with perhaps significant biases that you're unaware of. And I paraphrase that correctly?
Yes, that's correct.
Who else feels like that? Hands up. Well, yeah, I do. I definitely do. All right, so that's an interesting, very, very interesting point. I want to thank you for that. Someone, yes. Oh, hello, Dr. Park, please go ahead. I didn't see your hand up.
Just wanted to add that Korean government also engages in the type of blocking that Minister Tang has just described, and that creates a lot of interesting, amusing experience where only South Koreans cannot view North Korean government websites. If they go to Japan, if they go to the US, they go to Taiwan, they can see North Korean websites. And there are many websites that are blocked, that are available to everywhere else, but not available in South Korea only. For instance, there's a website that provides information on medical abortion, meaning abortion by medicine. That website is blocked only in 3 countries around the whole world. That includes South Korea. So that makes the user experience uneven, as Minister Tang has described. Now, what is interesting is if you are tech savvy, or if you are willing to pay $1 per month, you can use VPN. And you can, act like you are in Taiwan or Japan and access those websites. Now, what gets what clutters the problem is if the government becomes really serious about blocking, then they try to shut down the VPN services that are popular within Korea to access these websites. But that's exactly what's happening in mainland China now. So, fragmentation is not really somebody else's history. It's happening right now. We really need to have a philosophical discussion about, okay, internet gave us freedom, just like God gave us freedom. What does freedom mean? Well, freedom to make mistakes and apologize for it, repent upon it. Shall we really block these harmful contents through all these without due process, without really international discussion about it, so that people with resources can access all websites around the world, wherever they are. But people without access to VPN are limited in their access to knowledge. Thank you.
Thank you very much. I see, Benjamin, you can pop straight in. You will need to unmute.
Okay. Sorry. I really like the comment about the social media platforms and also what Professor Park was saying. So if I can talk about both, the internet is definitely fragmented, and for the large chunk of people who are not using the internet raw, most people, the average person out there is actually using internet mediated through the tech platforms. The experience of what is information coming through the internet is not from individual websites, it's going through social media platforms and is being controlled by algorithms. And the decisions of what gets through or what does not get through are being made by businesses that have obligations to their stakeholders, their shareholders in their particular community and society, and have obligations to their own sets of community standards, which may not align with the communities in which their content is being viewed. So there is a problem of fragmentation, not meeting the needs of the societies in which the information is actually appearing. So that's something that that's a difficult question, because should the governments, the elected governments that are supposed to represent their people, have a say over what the unelected tech companies, which are bigger than most of the governments of the world, are able to actually transmit across into their societies? Or is there a multi-stakeholder approach that needs to be applied to reach a discussion on what should be allowed in or not, as Professor Park was saying? Because in many senses, the content that's being regulated, and Mr. Auditang has given a good example of kind of content that we don't want coming in, malware. Or it could be in certain societies. I was in a meeting where it was very clearly shared that if certain messages were to come in, they would start riots, and they had already started riots in that particular community. So should there be an ability to stop this kind of content from coming in? So this definitely, we need to have more engagement, more discussion, and to where each community and society is going to draw those lines of fragmentation.
Thank you very much. And hopefully that's got some thoughts going. I've seen a real coming to the microphone, but first of all, we will go to a remote participant.
Thanks very much, Cheryl. We have a comment from Andrew Dalglish. As well as profile-based fragmentation and jurisdictional fragmentation, I feel there has always been a kind of longitudinal fragmentation. As just when I think I figured out roughly how the internet works, it transforms due to technical and service innovation, and I have to relearn.
Thank you very much. Over to you, Narelle, if you can.
I just want to have a question for Kyung Shin. How does it work in Korea with the ISPs and the content sender pays system? Because the system that we have here in Australia is that while the big telcos are fighting really hard to try and get the content players to pay them for it, what a lot of the content players do is actually connect straight into the IXPs, and the big telcos won't connect to the IXPs because they're like, oh no, we charge you for transit. So therefore you lot of customers, you need to pay us. So we have kind of the opposite situation where I, as the main IXP operator and a not-for-profit entity in Australia, we trunk a lot of content around the country in conjunction with the content providers. And I invite content providers onto my network all the time. Like, if you've got content, come to me. So it's sort of, why don't they use the IXPs more within Korea?
Well, I have a simple answer to that. There is no true neutral IXP in Korea. Each big telco has its own IXP. So there are three different IXPs for each of the big telcos. Gotcha. There are like three other neutral IXPs. Now, big telcos are not connecting there. So there is no IXP that the content providers can peer with.
Yeah. So here we have pretty much
telcos.
all the small ISPs in Australia, apart from the big four. Well, sorry, 3 of the big 4 don't connect to the peering points, but pretty much all the other ones do. And we serve about a petabyte of content per day. Yeah.
Yeah.
Food for thought indeed.
So should I try and come over to Korea and set something up?
So looks like an opportunity to me. Yes, please. We have another remote participant.
Makito Lei says, while we are in the same world, accessing the same internet, some content/services are not available to certain countries. For instance, Microsoft Azure and ChatGPT do not provide service to Cambodia.
Who would like to react to that one? Any of our speakers want to react? Oh, yes, Benjamin, do I see the microphone coming off?
I was wondering whether that actually is within the scope of our discussion, because it looks more like commercial choices.
Okay. Part of the issue, remember we started, is how we define internet fragmentation. And if you're looking at it at a different layer, where what it means to you is going to be different to someone who is operating, for example, in the technical layer. So this is part of the problem. You can say to people just seek their view on internet fragmentation. But exactly what it is they believe it is needs to be established first. And in some cases, the best way is simply to collect the data and use things like the impact assessment tool, which helps guide those very exploration points. What does it mean, right? They're the types of questions that we need to, and I'm getting on my soapbox and I promise to get off it momentarily. We need to encourage the decision makers, and this is where the case studies that ISOC are doing is so very important, to consider in all of this. All right, I'm going to look around the room once more and see if anybody has, yes, we do. Well, come on up. This is like, don't stand on, this is a town hall. Your voice is welcome.
So it's me again, Maristella, for the record. So I would just like to add that when I was thinking about regulations and ChatGPT not being available in some countries, or some apps are not available in Europe, I think it's probably not in all cases, but probably because of regulation also, but not in terms of infrastructure or the technical side of implementing it, but on data protection. Because I think this is one good side of it, that our regulation on data protection actually limits the applications who go inside our countries who are not able to protect our data. So if there are certain measures to protect us from unlawful processing and things like that, from to ensure data security, then it's good. But it also fragments the internet, because not everyone will be able to access the information that others are accessing.
Thank you very much. Anybody seeking our attention online, Joyce? Not at this stage. All right, well, we might take the opportunity to move to question 3, which will be our next slide. And I'm going to ask Benjamin to kick us off on this one, but welcome everybody's input, of course. We're going to move our discussion now, and that includes the audience, to what do we think we can do about internet fragmentation? Is it possible to avoid it, and how? Ben?
Thanks, Sharon. Okay, so I'm going to approach this in a different way. Before we do something, and actually what we need to do is to understand it better and to define it better and to actually have better conversations on what internet fragmentation is. Because as we all agree, internet fragmentation exists on a spectrum. Absolute no fragmenting and no is something that's feasible or desirable in the modern world, nor is absolute fragmentation. So somewhere along the line, there are instances of where it's desirable or not desirable, and that depends a lot on the needs, the aspirations, the objectives, the priorities, the values of the societies which are using the internet at any point in time. So my thoughts on what to do are to have better engagement, multi-stakeholder engagement on these decisions that are being made, and to be able to assess them according to a couple of criteria, which is intentionality, whether you are really making the decision to fragment with all the knowledge that is required, the impact, who are the people who may be impacted or second order that you're not thinking of, and also the nature of the needs of the societies that are involved. And this requires, in many cases, capacity building, because there are policy considerations that the technical community may not be aware of. There may be commercial needs that the rest of us who are not in the commercial side may not be aware of, and it's the commercial side that actually owns a lot of the infrastructure. There may be technical considerations that the policy people do not know about. So more communication among the multi-stakeholders and capacity building is needed. And that's how we avoid, in my view, not avoid internet fragmentation, but avoid undesirable internet fragmentation. Over to you.
Thank you very much. Is there anyone online wishing to go in? If not, let's go to the microphone. Thank you.
So I want to ask, Chad Ramilo for the record. So I want to ask a question directly then. You said avoid undesirable, internet fragmentation. So is there a desirable internet fragmentation? And I want to ask what would that be? And then the second part of the question is, what is the most undesirable internet fragmentation? Thanks.
Thanks for a very tough question, right? So the lawyer's answer will be, it depends. But okay, to try and give some examples, there may be situations where I think Minister Audrey gave a good example of blocking malware. Or in Singapore, authorities blocked 350 phishing scam websites because they were domain spotting. They were in fact being used in a huge cyber scam campaign that was going on, targeting one of the major banks. So in some cases, there are particular needs for fragmentation. And content is the most challenging one, because one person's protection of society is another person's censorship. And that's where the debates are going to happen. The very, very undesirable fragmentation is that everybody's got in different systems that are not interoperable. It breaks down communication, it breaks down trade, it breaks down the progress and development. But in between those, I think there are a whole lot of examples, and I invite my fellow panelists also to jump in with examples or totally disagree with me.
Let's see if they do.
I think that example that you gave, Benjamin. There are other equally urgent or urgent sounding examples. For instance, websites distributing child CSAM, child sexual abuse material. Now, when you see one, do you block it, or do you trace to the root of it and arrest the person who is doing the distribution? If you just block it, it will be viewed by other people. If, for instance, Singaporean government just blocks it, everywhere else, in other countries, it will still be available. So that's what I've been telling the Korean government about this. If you see foreign website distributing, harmful material that are targeting Korean eyeballs, instead of blocking it, you should go to the root of it. You should continue the investigation while the website is available, and track down the wrongdoer. What the government is doing by focusing so much resources on just blocking instead of so much blocking is actually derelict their duties to protect people. These days, a lot of police officers, when they see, everywhere, like, catching criminals, it gives them points for promotion, especially, child sex crimes gives you promotion. Now you're a police officer. What's your job? I mean, do you sit in front of a computer and trying to block those websites, or do you go out there and actually try to attack the root of the problem? I think the balance is moving more and more toward just blocking and not putting the resources where they are needed. And that's where I think sometimes, I don't want to say, it is bad fragmentation or it is bad blocking. I'm just saying there can be better blocking or better unblocking, right? If it is coupled with proper investigation.
I agree a lot with Prof. Park, and definitely we should definitely be pursuing the criminals. For example, CSAM is a very, very good example, or rather bad situation that is good. And really, having met with people from the Queensland police who have been actually able to track down, I think it is a very worthwhile effort. I think the great problem is that it's a long process which can take years to track down. The investigation that they carried out took several years to track down, and during that time, you have to balance it. The material is still available, and more material is being added and is being seen by people in the community which the authority has to take care of. So they have to balance. While is it maybe a compromise block and investigate? And in some cases, when they investigated, they were not able to actually apprehend the criminal because the criminal is in a bulletproof jurisdiction. And having discussed this with Interpol people, because we have a center here, this is a problem that there are many of these, whether it's fraud, whether it's child sexual abuse, whether it's ISIS, they are in jurisdictions where they cannot be arrested because of the nature of the government, of the place they're sitting in. So what do you do in that case? The only thing to protect the community is to block.
Audrey, did you want to come in on this one before we move on?
Yeah, I have a very quick comment. So as some of you know, Taiwan is top in Asia in terms of internet freedom. And I think our communities, especially human rights groups, tolerated the DNS RPC mechanism, not just because of its transparency, but also because it's not an effective paywall. Like even for malware sites, for court-ordered cases, which is very clear-cut, there are still like security researchers which has a legitimate interest in connecting to that domain and getting the malware code. In Taiwan's case, they just switched to a different DNS server in which if it's IPv4, it's 4 digits, easy to remember, or 1 digit repeated 4 times. But in any case, to circumvent that, you do not have to pay VPN or have a credit card in other countries. So I think that relative ease of circumvention, if you will, is what encouraged the multi-stakeholder adoption of the RPC mechanism. Thank you.
Is there anyone online? Great, because we've got a lovely lineup here. Over to you, Jen.
Sorry. Hello, everyone. I am an internet user from Hong Kong. I would like to keep my name and face anonymous in this intervention. I would like to ask, what can we do to everyone, and as well as the panelists, what can we do to people, ordinary people from countries that's facing a human rights crisis because they got cut up? And on this very day of the 4th anniversary of the 2019 Prince Edward Station attack in Hong Kong, I would like to bring up that getting emotional, okay, as a someone from there. You know, there's like a Hong Kong Chronicles where people cannot access the records of different political and protest event about the protests anymore. It's, you know, internet fragmentation can get very political, and I want to hear what everyone's in the room would, you know, see all these things happen around the world and what particularly we can do about internet fragmentation, because we, of course, have lots of people in Asia Pacific facing this similar situation. Like, for example, Myanmar, ordinary people got cut out. And so I would like to hear a little bit more about this area as well. Thank you.
Thank you very much, and huge respect for stepping up. Huge respect. Would any of our panelists like to react to that? Obviously, it's an emotive area, but it's also one where we risk a revision of history that does probably no one service, whether you're inside the demarcation line or beyond. Audrey, did you want to react there first?
Yes. Well, I personally work on the traditional Mandarin translation around the turn of century on Freenet, and that was designed to be a, back then it's called P2P, nowadays we call it decentralized web or something like Web3, but it's a family of technologies that are designed to be tamper-proof and to be censorship resistant. I think one of the main contributions we all can do is just like normalizing the use for end-to-end encrypted messengers like Signal, also to normalize the use of such decentralized web technologies. In my ministry, moda.gov.tw, we publish, before we publish to HTTPS, we publish to IPNS, which is the interplanetary file system. So you can find us on IPNS //moda.gov.tw. And in doing so, in running our IPFS nodes, in investing in IPFS technologies, and so on, we also contribute to the people who value this tamper resistance and censorship resistance in authoritarian regimes by normalizing its use and mutually pinning each other and backing each other up. So I would encourage people to learn more about decentralized web or Web3 if you're crypto-minded, and then normalize the use of such technologies.
Thank you very much. Any of the other panelists want to step in at this point? Okay, well, we do have a lineup.
I'm really happy that Minister Audrey has actually shared that, and I think it's a great example because we have actually in the present day moved away so much from the original technologies that the average person needs. We need to have give more awareness and more education to people that there are tools, there are platforms, Freenet, that they can use, that they are not restricted to the common commercial tech platforms that can be blocked, that can be stopped, that can be coerced.
Okay, over to you, please, Pepper.
Thank you. My name is Pablo. I work for APrIGF, and it's been a wonderful discussion. It made me think that most of what we're talking about is fragmentation at the jurisdictional level, and the jurisdictional fragmentation's impact on the user experience for the internet. And I think that was a very good unpacking of the question of fragmentation. But I want to go back to the underlying infrastructure, because I was a little bit worried by those comments about desired fragmentation and undesired fragmentation, as if implying that some fragmentation could be okay. And I think that is still part of the jurisdictional debate. Back to the underlying infrastructure, I think of the slogan of ICANN, One World, One Internet. And I do feel and think that we still live in an one single interoperable network, and in a way it can resolve universally if not prevented by those jurisdictional blockages or those jurisdictional elements. So I just want to feel if that is something that Minister Tang and Benjamin and Professor Park could agree on, and if we can depart from an underlying unfragmented internet as a desired thing to keep, defend, and fight for.
I'm going to ask them to, when they do their summation, respond to that, if you don't mind. And I'd like to take the next speaker, and then they can perhaps respond to you as well.
Hi, I'm Helen from APrIGF Foundation, although I'm just really asking a question about, or talking about internet fragmentation from a user's perspective. I just wanted to know what, if anything, we can do with regard to data collection and algorithms really leading to this fragmentation, because I feel that, you know, when you have just a thing deciding for you what you're allowed to know and what you're allowed to like, it's really limiting our information on something that we call, you know, the internet. It's supposed to be this information for all. And we have these algorithms deciding for us. And I think we run the risk of, you know, when everything is catered for you, we lose the ability to educate ourselves and question what's correct. And also to have that level of uncomfort that allows us to learn from things. And again, just, you know, in hearing from the other panelists, the amount that we're missing of what's happening in other countries because we have an algorithm deciding what we get to see. Thank you.
That's right. And I'm just going to take one final word, and we'll go back and they can all try and squeeze responses into everything. Andrew, you are closing me out.
Thank you. Andrew from TRBI Vanuatu. Well, I think the answer to this question is to defrag. Yes. So it is quite a broad topic, and as we know, there's no silver bullet to correct it, because there are, I think technically it might be fine, but there are other issues like the politics or the financial situations and the social implications, and even the security are some of the things that contribute to the fragmentation of the internet in different nationalities. So is there any way for, I know Pablo was talking about ICANN, one internet, one world. How effective is sort of uniform regulation across? I believe the only solution is to continue the dialogue, to continue to talk about it at all levels. But I fear that is this fragmentation forcing us to another era of internet governance. Thank you.
Thank you, Andrew. I'm going to ask each of you to do your best to have a go at a response to any or all of those last three questions, but particularly the ones raised from Pablo and Andrew. I also would like to just remind you that the clock is running. So if this can summing up, and we'll go in reverse order, I think. Let's start with you, Benjamin, and then we'll go back via Audrey and to Dr. Park.
These have been great questions and great comments, and I really just want to squeeze in. So when we talk about living in one world, one open network, do we live in an open network, or do we live in a world with actually countries that are different and have different restrictions and different views? Because they still, at the layer of the infrastructure, a lot of it is still under the control of countries, and you have to figure out how do we work with that. And we are also at the layer of the platforms that most people are communicating with on now, because so few people are on the raw internet that we actually knew from the 90s and the early 2000s. So are we able to educate people that there is so much more out there than they're seeing in their walled gardens? So much more, and I'm hearing the words more communication, more discussion is needed to help people be more aware of the different stakes that are out there, so that they know what's available to them. That even if there's oppression, that there are ways around it, but also that communities can be protected from undesirable influences or content or whatever it is, so that we know that we have choices and we can find the internet that works for us.
Thank you. Audrey?
Yeah, so to the question of over-reliance on algorithms that make decisions, in Taiwan, in our basic education, we make the distinction between media literacy and digital literacy, which is about consuming information, and media and digital competence, which is about producing information. And we found that when the students learn to, for example, produce fact-check reports, when the three presidential candidates are having a debate or something, and have their name appear on national TV, if they find something wrong, the candidates and so on, once you start thinking in a journalistic mindset, you become less likely to be influenced, manipulated by algorithms that make the decision for you. So I think one key point here is to emphasize on a contribution mindset, on competence mindset, so as to not to do the lazy habits of like just doom scrolling, and which straight leads to addiction, and that leads to the persuasion manipulation by algorithms. So this is one. And also I will note that I fully support the one interoperable internet, and nothing in the DNS RPC fast track notification trusted reporter mechanism is jurisdictional. I mean, between .tw or .asia, between trusted reporters, between threat indicator sharing by cybersecurity institutes, and so on. These can also be an additional layer that safeguards against malware attacks that is not entirely purely jurisdictional. Thank you.
Thank you. And finally, very briefly, Dr. Park. You're muted.
Well, I want to say, I mean, the train has left the station. The cat is out of the bag. The humanity already is received this gift called the internet that has given all people around the world, all powerless individuals, the tools to compete with the big companies and governments, and the jurisdictional fragmentation that's happening is short-lived, as satellite internet is being made more and more available. So we should stop holding on to the tools of the past. We should start developing the tools of the future to fight the harms that have justified fragmentation. The same thing with sender pay rule. that is financial fragmentation, where people imposed with network usage fees will not be able to make available their messages on the onto the online world. The same thing with the satellite, internet, and other technology. It will be more and more difficult to hold on to the termination monopoly that telcos used to enjoy. It is, we should really look to the future. That will be my
Excellent.
last comment.
Well, with that look to the future, I'm going to suggest that we all want to also look to the resources that are available. And I'll go back to what Noelle was mentioning to you with what is on the Internet Society's site. There are resources that you can use if you are talking to decision makers in your local community. Please have a look, continue the conversations in the places and spaces you work at. And let's do what everybody, I think, said here, and that is gather again in these types of conversations to get a multi-stakeholder, or at least between stakeholder, ongoing conversation on this very complex but very important issue. And one final reminder, might be one world, one internet according to ICANN, but it is still a network of networks. And therein lies the rub. Thank you, ladies and gentlemen, and please thank our fabulous panel today. Lunch.